Good morning. Good morning. Good morning, amazing law nerds. And for the replay crew, love you. All the timestamps are down below. And as a reminder, if you don't have time for streams every day, I totally get it. All the case briefs, which are edited and curated summaries of what we do on stream, are on the Emily D. Baker Show channel. So the Emily Show channel, not the Emily D. Baker live stream channel, and the Emily Show channel. And those drop almost daily. And then on Monday, we have the Emily Show podcast. So if you're not catching up on that, that is over there. Also, if you don't have the Law Nerd app, then you probably didn't know how late Emily was up last night. If you do have the Law Nerd app, you are probably well aware that Emily was up going, what? Wait, what? Wait, what? Because you were doing that with me. So for all of you that have the Law Nerd app and those of you that are in the Law Nerd Lounge, you know that we were talking about all things Karen Read last night, what we know, what we don't know, separating fact from speculation, from internet wildness. And today we're going to break all that down in the Karen Read case because, well, there's a lot we need to talk about. I've got the court documents. I've got the media reports. I've got a law degree. I have thoughts. I have questions. I've got my I have questions shirt on today. I have questions. I have questions. I have documents. I have media reporting. We're going to talk about what we know, what we don't know, and what we can know from what the court doesn't say. Yesterday, all of you that are like, Emily, you need the what do you mean meme from Jennifer. I do. I need a video clip of it to just be like, what do you mean? Because that's where I'm at. Because there's a lot that is unknown. There are some things that are 100% known, and we're going to talk about those. I don't think I can emphasize enough how unusual it is that someone who serves on a jury is actually charged with criminal contempt of court. And that's what's happening here. This was someone who was a grand juror on the Karen Read case. Keep in mind that Karen Read grand jurors, like all grand jurors, will serve on multiple grand juries. So we're going to look at everything that we know and we are going to talk about it because this is unbelievable. It's absolutely unbelievable. And for a federal grand juror, like this is a federal case. This is a federal case. Man, oh man, oh man. I was so surprised to see the headlines last night. Like I finished up with stream yesterday and said, we're going to talk about Donna Adelson. 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 And then I think I caveated that with unless something wild happens. And so this counts as wild to me because the unusualness of a grand juror being charged is particular. So we're going to go through the statements from the U.S. attorney, the court documents, and I did. Roy said, you said unless shit pops off. This counts as shit popping off. So we're going to go through the court documents. We're going to go through the plea agreement. We're going to go through the press release. We're going to go through the media headlines. We're going to talk about what we know. We're going to talk about what we don't know. I'm going to keep my sources of fact coming from there. So that's what I'm covering today. There are going to be lots more theories online. We will parse those in the days to come. I'm going to parse what headlines have been put out and we'll go from there. So that's how we're doing it today because, well, a grand juror has been charged with criminal contempt, and this grand juror did sit on the Karen Read federal case. So we need to break down what that even means, because there were multiple grand juries in the Karen Read case. And I'm not even traveling till tomorrow. So, oh, Nikki, no, there's leaked information. We're going to talk about that case too. That's this case. I don't know why I said that case. We have coffee this morning. We're not even through the coffee this morning. Carly in the chat, stay safe. Look, if Ryan Hall is live, this is one of Emily's policies. If Ryan Hall is live and talking about your area, I always have a replay. The replay crew is always here. I know you love being here live with the Law Nerds. The lengths that we go to make sure that the chat remains live is extensive. Like, we do planning around making sure that the chat remains live for you, so that even if you replay, you can see what your friends are saying in the chat. Because when life happens, you need to do the things. Thank you for the compliments on the nails. I am traveling to go see my kiddo. And so the nails are Shapeshift inspired, for those of you that have seen the Cavaliers show and show announcements. They are Shapeshift inspired. So they have all the things. So if you've seen any of the Cavaliers imaging around their show this year, they are Shapeshift inspired. Why? Because I'm that mom. So a lot of you asked, wait, you could see the live chat on replay? You can, Katie, and the mods will let you know. For everyone who went to see DCI last night, I know some of you were at Broken Arrow and saw the Bluecoats and Phantom Regiment and Carolina Crown and Spirit of Atlanta. I saw their show for the first time last night. I streamed it on Flow Marching. I saw Spirit of Atlanta last night for the first time. I saw MCDC, which I hadn't seen yet, which is local here to Nashville, for the first time last night. Though MCDC's show is called It Tolls for Thee, and there's not enough Metallica in it. And I'm like, if you're doing a like For Whom the Bell Tolls show, I'm going to need personally just a little, I need a little Metallica. I need a little Metallica in that. So I know the Broken Arrow show in Oklahoma was great. Bluecoats, look, everybody has done fantastic. But it's really cool to see some of the shows start to snap into place as we're getting closer to August. And Cavaliers have been doing that too. Kathy, I know Cavaliers won, and DS, we are getting a code for y'all. So give us 2 seconds. So we are getting a code for you. Anyway, so yes, the nails are new. I am traveling. We're going to go see DCI. I feel like I'm about to say, let's get ready to rumble, and then immediate copyright takedown. Let's get dangerous. Let's get ready to go. Let me know where you're coming in from, what you're drinking. We've got a busy day. And we've got a lot to talk about. Tozy, no, the grand jurors are not the jury from the first trial. We're going to talk about all of that. We should just roll the intro and get into it, because there are lots of questions, and we're going to need to talk about it. Let's go. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. I know, we're bopping along. So if you saw the headlines last night, I think the first headline was from the Boston Globe. Subsequent headlines came out. Boston Globe, let me back up one sec. I always look to see if media outlets that are reporting on the same thing are doing independent reporting or the same reporting. There are times that outlets, especially if they're in the same family of networks, just grab each other's information and just skin it and put it up with the same byline and everything. Yahoo does this all the time. Yahoo puts it up, scrapes the headline off of it, still has the same byline, and just grabs it. And a lot of media outlets that are under the same umbrella of media outlets will just reshare the same information. So as I started seeing this, I wanted to make sure that what I was seeing was not just one source. So I saw the Boston Globe headline, we're going to go through that together. Boston Globe says they have 2 sources indicating that this grand juror who has been charged is A, from the Karen Read case, and B, leaked information related to the Karen Read case. Boston Globe is not in the ABC family of information or of networks. So ABC outlets are also saying that they have a single source verifying the same information. So we have multiple outlets, and then they say multiple sources, though there could be overlap in those sources. It could be one person saying things to multiple outlets. So we have to keep A, in mind what we don't know. B, this is breaking news. The story is likely to continue to develop. And C, we have to learn what we can learn from the court documents, because we're not going to learn a ton more than what we have in these court documents unless we hear it from one of the attorneys. Because unnamed source here and unnamed source there and unnamed source here is a whole lot. But it's what we got, and we're going for it. So I think the best place to start on this story is the Boston Globe started breaking the headlines yesterday that a woman charged in Massachusetts with criminal contempt of court is in fact a grand juror from the Karen Read case and was leaking information related to the Karen Read case. That is what the media headlines are running with. They say they have confirmed it. I said that weird. They say they have confirmed it through multiple sources. They have not cited those sources. They have not named those sources. They do not have to, but that is what they have said. I went and pulled the court documents. I pulled the press release from the U.S. Attorney's Office. So we're going to start with the court documents and juxtapose what we learned from the media articles and the court documents. My cautions are, 1, grand jurors who sit on federal grand juries. And remember, in the Karen Read case, there were 2 grand juries. There was a state grand jury that charged her in June of 2022 when her charges were enhanced. And then there was a federal grand jury. The federal grand jury, from all of our understanding, was not looking into charging Karen Read. That makes sense to me. A federal grand jury would not be looking into charging Karen Read with the death of John O'Keefe. That's not what a federal grand jury really would be looking at. We have heard that the grand jury was looking into the investigation of the Karen Read case. This is the federal grand jury where we heard from numerous witnesses in the trial that they testified at that proceeding. Jen McCabe, Carrie Roberts, ARCA. That's where ARCA came from, right? That's where we got ARCA from. The defense says they didn't even know about ARCA until they got all the discovery from the feds, because the feds dumped thousands of documents on the prosecution and the defense. And the defense was like, we found gold at the end of the rainbow. This never happens because of this case. Every lawyer everywhere is like, that never happens. CEG Karen Read. Well, that doesn't happen. Karen Read. This doesn't happen. Karen Read. So the federal grand jury, it seems to me, was looking into things surrounding the Karen Read case and investigation. Local prosecutors are not part of a federal grand jury. The defense is not part of any grand jury. They're most a part of grand juries, it seems, in New Mexico, from all the jurisdictions we've looked at. The feds do not bring anybody else into a grand jury. It is the grand jurors and the prosecutors. So the U.S. attorneys. Generally, especially on federal grand juries, you will sit for either a couple days a month, 1 day a week, but you will come in periodically and sit on numerous cases over the span of either 6 months to a year. And so it's not just one case that grand jurors will hear. So there is always caution when we were talking about a grand juror leaking information in a case to know exactly which case. And we're going to have to take all that information that we have and see what we can sort. Because grand jurors will sit on numerous cases. And grand jurors sometimes indict, sometimes they don't. Sometimes grand jurors look into a case and investigate and don't bring anything else up. When a grand jury ends, it doesn't necessarily mean an investigation has ended. It means that a grand jury has ended. So you can have a charging grand jury or an investigative grand jury. So it really just depends. Let's go to the press release yesterday from the U.S. Attorney's Office in Massachusetts and start there. Yes? Yes. Massachusetts woman charged with leaking grand jury information. That we know. So, Boston, I have no idea how to say this. Dracula, something like that. I can't phonetically sound things out, and Massachusetts doesn't give a shit about phonetics anyway. Massachusetts is like, we pronounce it the way we want to. Some of you are saying Dracula, some of you are saying Drake-it. We'll go with either one. Dracula. A Massachusetts woman. Even the chat doesn't agree. Half of you are saying Drake-it, half of you are saying Drake-hut. It's half-half. We need to appoint an expert in all things Boston. Wait, we have those on Instagram. Oh, wait, we're going with Dracula. A Massachusetts woman has been charged with allegedly, this is why I pull these up so you guys can read it. Some of you are saying it's just Deaver. Who said Draco? That works too. That works too. A woman has been charged with allegedly disclosing information presented to a federal grand jury to unauthorized individuals. So, this says allegedly. That is part of the press release. We have a plea signed. A plea has not been entered yet, but we have a plea signed on the record. So they have already agreed to plead guilty to this. They have not changed that plea in court. The U.S. Attorney's Office is actually really good at this. They are very clear about alleging what's going on until there is a change of plea. They do a very good job with that. So that's why alleged is going to be in all of this. Allegedly disclosing information presented to a federal grand jury to unauthorized individuals. More than one individual. Information presented to a grand jury. Jessica Leslie, 34, was charged Friday, July 11th with 1 count of criminal contempt. So if you're like, how did the media know about this? Excuse me. If you're like, how did the media know about this? Well, the U.S. Attorney's Office did make a press release yesterday. I mean, it's Wednesday, July 16th. They made this yesterday. And I would imagine that most media outlets in Massachusetts get alerts when stuff goes out from the U.S. Attorney's Office or get these emailed to them directly from the U.S. Attorney's Office when there's a press release. So, charged Friday, July 11th, 1 count of criminal contempt. Defendant has agreed to plead guilty and will make an initial appearance in federal court in Boston at a later date. That later date's July 22nd. It's already on the docket. A plea hearing has not yet been scheduled by the court. That could also happen on July 22nd. I keep saying might happen or could happen on July 22nd because it's an initial hearing and the court could say, come back in a week. I doubt it because it's already signed and taking a plea doesn't take that long, but we'll see. So the initial appearance is going to be July 22nd. According to the charging documents on various dates between more than once. This is information shared to more than one person, more than one time. Various dates between August 11th and March 4th, the defendant disclosed sealed information to unauthorized individuals, including the names of various witnesses appearing before the federal grand jury. That's a huge no-no. The substance of witness testimony and other evidence presented to the grand jury in violation of the federal rules and court order. Remember, because the court says to the jury, you're not allowed to do any of this. So this is a violation of the court order and the federal rules, which is why it's a criminal contempt charge. Y'all ask me all the time, is there any way anyone's going to jail? And I'm like, well, I mean, there's an off chance of like contempt, but that's like way down the road. So here's contempt, not the emotion, not vibes. Criminal contempt. There it is. We never get to talk about it. The criminal charge of contempt provides for a sentence of any term of years in prison, 5 years of supervised release, and a fine of up to $250,000. I really think you should fine people. Just fine people. I mean, going to jail is maybe a lot. I think people should have to pay. I think people should have to pay, at least for the cost of investigating this shit. You were told not to do it. You did it. Now you have to pay for the cost to find you and prosecute you. Like, pay the government back for not following the rules. Add it to somebody's taxes. Just keep going. So, we're going to talk about what the plea is for. That's not what the plea is for. That is the maximum possible sentence. Noreen says she's telling them everything, right? I mean, if you find people will mind their pockets. I mean, businesses, not always. Companies are like, it's worth it. Like, we'll take the hit on the fines. But individuals, like, there's days I feel fined when I'm just going to buy eggs. So I get it. But I think you will actually get fined for this is an incentive. So a criminal charge of contempt provides for a sentence of any term of years in prison, 5 years of supervised release. That's a long time on probation, by the way, and you generally have to pay for probation. And a fine of up to $250,000. Sentences are imposed by a federal district judge based upon the U.S. sentencing guidelines and statutes, which govern the determination of a sentence in criminal cases. United States Attorney Leah Foley and Ted Docks. That doesn't even sound like a real name. It sounds like an undercover name they would make up for somebody. It's like, what's your name? My name is Ted Docks. No offense, Ted. Ted is the special agent in charge of the FBI. Wait. The who? Chat?
The FBI!
That's Ted's undercover name. I'm teasing. Joe just said, my name's Jeff. Exactly. Boston made the announcement. Leah Foley and Ted Docks from the FBI made the announcement today. Assistant U.S. Attorney Ann Prudy, the chief of the Major Crimes Unit, is prosecuting the case. You do not want the chief of the Major Crimes Unit on your ass. I will tell you later how offended a prosecutor would be by this. The details contained in the charging documents are allegations. The defendant is presumed innocent unless and until proven guilty beyond a reasonable doubt in a court of law. Well, they're going to plea. So it's giving guilty vibes because they've already signed a plea deal saying that they're going to plead guilty. They just haven't done it yet. But our system is predicated on people being truthful. And people adhering to their word might start to seem like an old-fashioned notion. And if that happens, I don't know what we're going to do with the jury system. I will say that not just talking with I saw somebody talking about the leaderboard and I'm like, wait, what? Lori, see, you can make it go away on your end. This is why we have the rules in the chat, because my brain will literally go, what? From the conversations I've had with jurors, and I've spoken to a lot of people that have served jury duty on my cases. I've spoken to people that since I started doing this will come up to me in public and share with me about being a law nerd and share with me their jury experiences. People in my personal life will be like, I got someone for jury duty. I will tell you all about it. And they do. They tell me what the experience is like, what the process was like, what they thought of the judge, how uncomfortable the chairs were, how cold and or not cold the courtroom was, what they thought of the lawyers. But people don't talk about their deliberative process. Oh, Lori, you're all good. It's not you, it's me. It's my brain. It's why I have the no caps rule, because certain things will just grab my brain. It's totally not you. I'm glad for you too that it's gone. I'm glad. So for the kids, I'm saving this comment. So no need to apologize, Lori. And I didn't want to make you feel like any kind of way. I was just explaining why my brain jumps sometimes when I clearly say a word that is not in my sentence. It's generally that I've seen something and my brain is gone. That word will substitute. It's like if you're writing something and listening to music and all of a sudden you're writing lyrics, you're like, what happened? From all the conversations I've had, people take jury duty very seriously. It is rare that people don't take jury duty seriously. From all of the law nerds in the chat, and every time we talk about jury duty, everyone who has served jury duty says, I took this real serious. I took it really seriously because you are dealing, oftentimes you're serving on a trial jury, often called a petite jury, and you're looking at the person who you're being asked to decide if they did the thing. Here's where a grand jury is a bit different. Oftentimes the defendant is not there. So it is a lawyer presenting you a bunch of evidence and witnesses. And oftentimes you're not looking at the defendant. So it's a little bit different. I think it's great because if you're on a grand jury, here's the thing. If you're on a grand jury, you can also ask for more information oftentimes. You can send subpoenas. You can be like, we want to see these records. We want to see this. You become, in most cases, part of the investigative process. At state level grand juries, like the grand jury we talked about in the Baldwin case, in the Read case, and in others, oftentimes it's the prosecutor and witnesses presenting a case and saying either, did we prove these charges? I mean, Koberger had a grand jury. Did we prove these charges, not beyond a reasonable doubt, by vibes? I'm teasing, it's not vibes, but the standard is it more likely that this person did it? Is there like meh enough? So if you are at a grand jury that is charging, you will either be given a list of charges and say, hey, did we show you that this person did these things? This person not sitting there did these things. Or, hey, grand jurors, so like with the law, do you think this person violated the law? Would you like to pick what they did? Tell us. So sometimes grand jurors can add charges or decide the charges, sometimes not. It really varies by jurisdiction. So when we talk about grand juries, I feel like I'm going to start to need a chart. When we talk about grand juries, you can have investigative grand juries that are trying to figure something out, and you can have charging grand juries that are presented the evidence instead of a preliminary hearing to see if there is probable cause that the person arrested or to be arrested did the things that are being charged. So it is a baseline level of evidence. We watched a preliminary hearing, I think most recently in the Corey Richins case. We had been gearing up for a preliminary hearing in the Brian Koberger case, which the defendant is there, the defense is there, there's cross-examination, and then the court decides if there's probable cause. At a grand jury, the witnesses are presented to the grand jury without the defendant, without defense counsel. The obligation under the law for the prosecution is to present things that are both inculpatory and exculpatory. So if it's like, yeah, but there's also this, the grand jury has to consider all of that to get to probable cause. And so you can have that at the state level or at the federal level. And oftentimes at the federal level, when you have a grand jury, which is really most of the time if they're charging someone who they haven't already made a plea agreement with, you have a federal grand jury, it's sealed, then they go arrest someone, then they unseal it that day, like in the Jen Shaw case, right? They went and scooped Jen Shaw up in the parking lot of Beauty Lab and Laser before she got on a Sprinter van. Well, she actually fled from the parking lot at Beauty Lab and Laser, but you know what I mean. For those of you that don't watch Real Housewives of Salt Lake City, just it's a hypothetical. Give me a minute. Well, it's a fact-based example. But the indictment stays sealed until they go grab the person because they don't want the person to run, to destroy evidence, to wipe all their computers, hide money, flee the country, whatever. So they keep it sealed until that person is scooped up. Then they unseal it. Then there's normally some type of a press statement like we see with this thing happened. They will oftentimes, when you see large federal operations, they will oftentimes hit numerous locations that they're worried about evidence at once, simultaneous to the person being arrested. It was really unusual in the Diddy case that they hit multiple locations with search warrants before they arrested him before a grand jury. That was unusual to me. And I was like, oh, it's coming. It's just a matter of time. But oftentimes they will have all that information and the Fed's case will be pretty ready by the time they go to grand jury because we're doing a whole lesson in law. I hope it's helpful. In the state system, if you don't heavily work on a grand jury system, oftentimes a thing will happen, law enforcement will investigate, someone will get arrested, and then the clock starts. There is timing limitations on when you have to charge someone. So the charging of someone has to happen pretty quickly from the time they're arrested. And so when cases come into file, you have a really limited period to turn that around, and you often have limited information. This is easier if you have a percipient witness surviving victim to the thing who's like, that person did this thing. And then police are like, that person is who I arrested. And then law enforcement goes to the district attorney and says, these are the charges we think, file the charges, set the bond, go and get arraigned. That gets squirrely if it's like a Monday court holiday and somebody gets arrested on like a Friday, then you're going to sit in custody until like Tuesday, depending on the jurisdiction. Some jurisdictions will run arraignment court over the weekend and overnight. It just depends. So that clock starts real fast, and then the speedy trial right starts. So arrest, arraignment, and then you have to have some kind of probable cause declaration or determination. And that can either be a grand jury or a preliminary hearing. When you are zooming through this, preliminary hearing is what a lot of states choose. Some states regularly do grand juries. It just depends. And then the trial clock starts for speedy trial. And if the defendant's like, I'm not waiving my trial rights, depending on the case, you need to finish your investigation quickly to go to trial. If you are the feds, you have a case and you're like, let's see. And the Fed's biggest concern is statute of limitations, but in the kind of cases the Feds are doing, oftentimes those statute of limitations, if they exist, are extensive and long. So the Feds have time to work up their cases first and then present it to a grand jury and then arrest someone, and then the speedy trial starts. Where the state system often is much more of a hamster wheel because the arrest happens first and then the investigation, because they are arresting people when things happen. Somebody crashes their vehicle into a house, you arrest them, and then you figure the rest of it out. You're like, this person drove into a house. We're going to start with, you can't do that, and then we're going to work from there. This is why you see, especially in like DUI and stuff, all the laws about when you get a warrant to do a blood draw and the timing of all of that, because also that evidence, well, can disappear because your body will work the alcohol out, stuff like that. So the federal grand jury is oftentimes done after they've investigated something. In this case, the federal grand juror was sitting on numerous grand juries. And all of the media is saying this is about the Karen Read case. We'll talk about that. But grand juries don't always charge somebody. It's part of the reason they're secret. Grand juries don't always charge somebody. So imagine you hear all this tea on someone and then you decide not to charge them. You can't just go spill their business. Also, sometimes investigative grand juries are still investigating. And if you let someone know, hey, this person's being investigated, it can, and I'm not being hyperbolic in this, it can actually put people's lives in danger. Because if somebody testifies to a grand jury that's investigating and that person testifies to get, I don't know, additional documents or additional bank records, and they are speaking on somebody up the chain, and they find out that that person spoke at a grand jury, that witness might no longer be available if the people they're speaking about who are still out of custody find out. That is not an unrealistic situation. Few things made me as mad as cases where people went after witnesses. If you want to see it pissed off Emily, ask me about cases that I've had where people went after witnesses. Look, you don't go after witnesses. You don't harm. So, you cannot share by court order the things that happen in a grand jury. Also, there's room for destruction of evidence. If you start talking about the shit that's happening in a grand jury, there's room for destruction of evidence. Because the grand jury might not have gotten all of somebody's computers or records or what have you. So grand jurors on a federal grand jury are people that are summoned for jury duty, just like people are summoned for regular jury duty. For the kids, I've had cases where people have killed witnesses. So I take it, I'm talking about my own personal experience, not the cases I've covered. It pisses me off. So when we are talking about why grand juries are secret, this is part of the reason. So when people talk about it not being a big deal, it might not have caused a big deal in this case, but it can be a very big deal. And it can be a massive safety issue, but it can also be a destruction of evidence issue. So I'm sure there will be people that say, well, it doesn't, I mean, just talking about what witnesses testified isn't a big deal. It is a big deal. Even after the fact, even if those individuals testified at trial, it is a big deal because there are rules in a system, and B, it doesn't matter exactly what this case was. If one person is not adhering to the rules, I am not surprised that the feds are going to be like, we are not going to let that stand. We are not letting that stand. So I think federal grand jury service is amazing. Trisha said, I would love to be a grand juror. Same. I would love to be a grand juror. All the tea. But you have to take that seriously. Because also, U.S. attorneys aren't necessarily going to tell you what case witnesses might be threatened in. As a grand juror, you're not going to know that. Grand jurors, Valerie, can discuss their experiences like saying, I was on a grand jury and we came in these days and lunch at that courthouse was good and the jury seats were comfortable, but they cannot discuss the cases that they were on, the witnesses that they saw, the attorneys that were there, what judge they were in front of. They can't talk about the process. It's not a public process. When you do a jury trial, it's a public process. Anyone from the public can walk into a jury trial and go see what's happening. And so when you are in a public trial or a petite jury, a trial jury, you can talk about it. You can't be forced to talk about it, but you can choose to talk about it. But if you are on a grand jury, whether the state level or federal level, you can't talk about it. Even if it becomes public, even if a grand jury charges someone, a grand jury charged Diddy. The grand jurors can't come out, and this was a problem in the Diddy case. Grand jurors can't come out and say, this is the evidence we saw at the grand jury against Diddy. A witness left the grand jury and said, I was a witness on the grand jury, and that was a huge issue. It's wild. And the court was fucking furious because federal judges are like, how dare they? However, you're told at the beginning of a grand jury what the rules are. And they ask if you can do it. And if you can't, the obligation is to say no. Kristen B said, what about once the case has been closed? No. Grand jurors cannot talk about what happened at a grand jury ever, period. There is an asterisk to that unless law enforcement asks them or they are asked in another court of law. If they are asked in another court, did you say this or hear this or see this? There is a limited exception for if the FBI knocks on your door and starts asking you about things at a grand jury, maybe. But no. Ever, no, period. Yeah, first rule of Fight Club. Trial juries are public proceedings. Grand juries are not public proceedings. And they are secret. Do I think the feds are going to charge someone because they went home and told their partner a thing? No. How would they ever know that? It's bigger than that. But yes, also, I think it's fair to share part of why I see this the way I see this based on my own personal work experience. Chloe asks, it would really depend on what the rules of that court were. They would probably say no. But it would depend on how that judge gave each rules. Rosie asked, are grand juries unique to the US? I really don't know. Our system, as we talked about yesterday, has a lot of different levels of government because we have a federal government and then state and local governments. And we have multiple court systems, which makes it difficult. So we need to get to the court documents. I'm going to keep your questions. I'm grabbing them as we're going down. Is a petite jury seen in historical town meetings the same as a trial jury? Generally, yes. When people are talking about a petite or petite jury, they mean the trial level jury, the grand jury being the secretive one. You'll hear jokes about grand juries, like a grand jury can indict a ham sandwich. People joke about that because A, the standard's low, and B, there's no defense attorney there. So Kimber Bell said, what's the difference between a jury and a grand jury? A grand jury is a secret proceeding before trial. A jury, as we colloquially call them, like a petite jury, a trial jury is a trial jury. Donna, I'm holding on. A couple of you have questions about that. I'm going to hold on to it. So the rules of evidence are different with a grand jury. Anna, they are slightly different because the rules of evidence that apply at a preliminary hearing or a grand jury before trial, the standard of proof is different. So there are some slightly different rules. Let's go look at what we are hearing from court and then what we are hearing from media. But there's a lot to keep. Not Rentschler's sandwich. I saw that, Lucy. Lori, I'm going to save this. Not like a job. Paid like they get paid for jury duty, because you normally are showing up for just a few days a month over a period of months. Like, dude, sign me up. Just sign me up. Sign me up. I want to be on a grand jury. I'm nosy. I want to know the tea. Then again, I don't know if I want to keep the tea from the law nerds, because these will become stories. And I don't want my stories to be like, oh my God, so Friday in the cafeteria. It would just make me feel like I'm in like high school or junior high or law school. Timothy, I don't remember. It's not a per diem. It's like a daily pay. I guess we could call that a per diem. You're welcome for today's Law Nerd University. So here's our key takeaways before we look at court documents. A grand jury is a secret, non-public proceeding. The things that happen at a grand jury remain sealed. If the case becomes public, the grand jury proceedings still remain sealed. You'll remember in the Koberger case that defense attorney Ann Taylor was saying, Your Honor, we still need the information from the grand jury because it took the defense a while to get it. You'll remember in the Karen Read trials that both parties were like, we don't have everything that happened at the grand jury. And finally, they got some of the transcripts. And they were able to ask the witnesses about witness prior testimony. But they only got the transcripts of the witnesses, it seemed, that were testifying at trial. So it's like, give us your witness list. We'll give you what you need to know. We'll give you the witness prior statement. Because grand jury proceedings are sealed, even if that person goes to trial, what happened at the grand jury, separate from the trial, is still sealed. So jurors can't talk about it then. So if you were a grand juror on like the Diddy case, you can't go to the media and say, oh, well, at trial, they showed this. And at the grand jury, we saw this. And at the grand jury, we saw this. And I don't understand why the trial jurors did this. Even though the trial is public and now resolved to verdict and acquitted on a lot of counts, the grand jurors still can't talk about it. Let's take a look at the charging documents from the Boston woman charged with leaking information in a grand jury case. We're going to look at all the court documents before we go to the headlines. And then we're going to take some inspo from Hogue and headline and hang out and see what the media is telling us, what the media is not telling us. Let's see. I saw the question for the kids up at EDB. If you weren't a lawyer and officer of the court, would you be able to hold the tea? Yes, because I'm also a very good rule follower. I wouldn't like it, but yeah, if that's the rules, if I can't do it, it's like when you're on the airplane and they're like, can you, if you're on the emergency exit row, are you cool with opening this door and stuff? If you're not cool, say you're not cool. Some people are going to be like, that doesn't work for me. I don't want the weight of that. And there's nothing wrong with that. If you're called for grand jury service and you're like, I don't want the weight of holding all of this. I don't want the weight of holding all of this. That's okay. All right. Chat, today is going to be difficult in that I'm going to ask you to stick with me in what we're learning from the court documents vis-a-vis what is out there online about this. I move more slowly with letting things play out than the online space moves. And I know that that can be frustrating and uncomfortable. We will go through exactly what we know. Everything that's not in the court documents is going to be based on, things not in the court documents. So please hang with me because I don't want to accidentally time you out or yeet you because there is so much spinning online about this. And there are things that are just not facts that are in that online space. And I'm very mindful of not presenting things that we don't know to be verified yet as verified. So thank you, law nerds, for hanging with me. Let's get to the charging documents. I should have swooped. You know what we didn't do? We didn't fly to Boston. Forget the swoop. We didn't fly to Boston. Let's go. All right. I try to keep it. FL fan said, thank you so much. I try to keep it grounded and I try to answer questions. What's hard with that is that there is a ton of wanting to know. I want to know everything too. I do. We don't yet. We don't know everything yet, and that's okay. It's just uncomfortable sometimes not knowing. Can we get some hearies? I need to put them on the soundboard. I still haven't done that yet. This is from July 11th, 2025. United States of America versus Jessica M. Leslie. Look, I'm not going searching for this person. I'm not going looking for this person. I am sure the internet between yesterday evening and today is already doing all the things. I am not. I don't want to. I don't want to know. Don't send it to me. I won't look at it. I don't want to know. So thank you. Also, I don't know how people are going to be sure that it is this person. And that starts getting into me in the realm of like, in a high profile case, do we really need to go there? This behavior sucks, but it's going to be accounted for in court. We have process in court. I trust, well, most of the time, court process. All right, I know I need the first few documents to shipping up to Boston. Has Boston Crusaders ever done that like beginning chords in a show? Like, have we done like a shipping up to Boston show from Boston Crusaders? I need to know. I know they did like a little nod to Wellerman in their Moby Dick show, but I have questions. That information I'm open to. Show title and year, send it to me. That I want to know. Send me banned things. Don't send me any information about this defendant I don't want to know. Criminal case number, count 1, criminal contempt information. Count 1. And the dates are important. It's also important to remember this is a federal case. From on or about August 11th through on or about March 4th, 2024, in the districts of Massachusetts, the defendant, Jessica M. Leslie, knowingly and willfully disobeyed and resisted a lawful order, rule, decree, and command of the court of the United States. Federal court, not state court. If it was state court, this would be handled in the Commonwealth, not in the U.S. District Court. When you see the case say USA, it's a federal case. You will also see United States District Court up here and which district, so you know which state we're in. If this was a Massachusetts case, it would be Commonwealth versus name. Federal case. Knowingly and willfully disobeyed and resisted a lawful order. You want to see courts get mad? Disobey their orders. Violation of Federal Rule of Criminal Procedure 6E2 and an order and command of the Honorable Indira Tawani. Oh, my brain went Trelawney. My brain's gone. We started with Harry Potter today, and my brain has continued that way. But Indira, what a lovely name. I agree. Olivia in the chat said, such a beautiful name. Agreed. Federal judge. Vibes, Your Honor. Your Honor, your name is a vibe. Can you imagine disrespecting this judge? I don't know anything about this judge, but still, it's a federal judge. Federal judges are fucking scary. They have no patience. Oh my God. So, order of the judge, because the judge tells the jury, you may not discuss this with anybody. That is a court order. And they tell you all day long. United States District Judge told them on May 26, 2022. Karen Reed was charged with the enhanced charge in June of 2022. This person could have been, well, this was likely when they started their jury service, though they would have been told this more. But when you are a federal grand juror, you are normally a federal grand juror from, the date that you become a federal grand juror for 6 to 12 months. So the grand jury this could be related to could have taken place, well, before August 11th. So the information received started between May 26, 2022 and August 11th. Because August 11th is when the yip yapping started yip yapping. when the chitty chat started chatting. Because the violation of the order is between August 11th and March 4th, which means these are numerous conversations. That's when the chitty chat started to happen. A long time. The order was given to not say anything on May 26th. And the order was that a grand juror must not disclose a matter occurring before the grand jury. And on diverse dates, chitty chat, she, defendant, disclosed information presented to the grand jury to unauthorized individuals. We'll talk about the rehoming of the phones. I don't think it's related to this. I'll tell you why. Individuals. More than one. And disclosed these things specifically. The names of various witnesses appearing before the grand jury, the substance of their testimony, and other evidence presented to the grand jury. All while said information was under seal and not subject to disclosure. What I do want to know is when the federal information was disclosed to the attorneys in the Karen Read case. Because it very much says not subject to disclosure. Now, there will come a time in a case where things may be disclosed, and then this gets a little harder. Things got disclosed in the Karen Read case. To both sides, to the prosecution and the defense. Remember, the federal grand jury did not give information to either side of the state or the Commonwealth case. The prosecution didn't have it. The defense didn't have it until they all got it. So I think the dump was March 2, Julia, sorry. Julia said, I think the TUI dump was March 2024. I think so too. I think it was right around there. So it's interesting to me that this date is also March 2024 because it seems to be right around the same time. They also made the specificity of saying, while the information was under seal and not subject to disclosure, though that's going to be true in every case. So, disclosed various witnesses, substance of their testimony, other evidence. This could be on one or multiple cases. This does not say how many cases it's covering. It covers multiple witnesses appearing before the grand jury. Grand juries hear multiple cases. This could be multiple cases. That is a possibility. We know that multiple individuals were told. We know that they were told on numerous dates. And we know that the chatting was happening over a time. Okay? You guys have lots of questions. I'm holding on to all your questions. M said, did it say when they found out? No. Tosha Beans, I'm going to answer that question when we get to questions. All right. Sorry. We had storms rolling through. And we have storms rolling through. We're back. Storms. Let's see. I'm going to message Dr. B to double check. All right. Let's continue. The weather is spicy here. But we're back. So, disclosed information to multiple people the internet being spicy is not good at all. Hold on. Dr. B, of course, is not responding to text message. So this is being spicy and I don't like it. We're going to call Dr. B real quick. Stop it. Give me 1 second. Gonna Fawcett, the Karen Reed state indictment was June 2022. We're talking about a federal grand jury. So a little bit different. A little bit different. Let's continue on. We're literally paging Dr. B. We went through the indictment. This complaint, this is not an indictment, July 11th, 2025. Filed July 11th, 2025. Disclosed on Monday. Or, no, yesterday was Tuesday. Emily, what day is it? Let's go to the next item. Our next one is the plea agreement. So we're going to go through that and see what we learned from the plea agreement. For those of you asking, have I been paging Dr. B? Yes. Has he responded? No. Hey, can you come to the office? Thanks, Dr. B. I've been texting you. The chat is like, uh-oh, Dr. B didn't have his phone on him. The chat knows. The chat knows. The chat is like, does Dr. B not have his Apple Watch on him?
I walked downstairs for 2 seconds. The moment I walked downstairs.
I don't want your excuses. I want you to fix the internet. The internet is getting all spicy. I don't think the weather is spicy enough for the internet to be getting spicy. But now I'm getting spicy.
I'll go look at the router. I'll give you a color update.
Will you also reach out to the internet and ask them WTF? Thank you. I mean, you don't have to use that language. Also, your Apple Watch does ring when I call the phone. Dr. B only has his phone on him when the internet is not a problem. Dr. B is sassing at me in my own office. Hey, Dr. B, the last time that the internet went down, you said that you would have your phone or your watch on. The chat is now being like, when do we get a members live to hash out Dr. B not having his phone on
I
him?
do not have my watch on because I went for an MRI this morning. And you can't wear it in the MRI?
Are you in an MRI machine now?
Since I'm home, I did not put it on.
Are you in an MRI machine this
I do not
moment?
have my watch on at all. For the doctor, so.
Can you figure out why the internet's being spicy, please? When anyone's like, so does Dr. B see information on a case? This man is not reliant on technology. I'm reliant on technology. Dr. B is not reliant on technology. However, you're never going to go to dinner with Dr. B and be like, why are you on your phone? Which is lovely. You're never going to have to worry about it. Dr. B doesn't give a shit about being on his phone. Which only comes up once in a while when the internet's being spicy. Are we ready? Are we ready? Why is he fixing the internet, Lori? So I won't yell at him more. That's why. So I won't be mad. He's calling and like, hey, you guys, when we had the week that the internet went down multiple times because people like dug up the lines, which ended up being what happened. The line just got fucking severed. One of my neighbors also works from home and runs quite a lot of their business on servers. And so all the generators in the world don't help us when the internet line gets severed. The fuck? Okay. I'm so annoyed with the internet. I figured I had to clarify. The other question I should have asked Dr. B is your phone charged? Dr. B is not going to power cycle the router. We did have that conversation. All right. Let's continue. This is the plea agreement. This was filed July 15th. Yesterday, Tuesday. Today feels like a Tuesday, so I keep saying Monday, Tuesday, July 15th. Note that this letter is dated July 11th. Why does that matter? Because the charging document and let me grab the charging document. The charging document and the plea document are from the same date. Why does that matter to me? Because that only happens when there have been conversations beforehand. That does not happen by accident. That does not happen by chance. That happens when these conversations happened beforehand. When I covered the Matthew Perry case, we saw this in some of the cases. When the complaint was filed, the plea was filed either at the same time or within days of the complaint being filed. So we're going to charge you with this and your plea is going to be this. So it's all sorted out before the charges even drop. So there will likely be 1 and or 2 court dates in this and then follow up on probation. So it matters that they're so close in time because it tells us that this conversation was happening with the feds before the filing was ever made. This was not a surprise, you're getting arrested, you've been charged by the feds. Well, I think Jen Shaw knew that case was probably going to come, but in the Jen Shaw case, they went and arrested her, pulled her in, interviewed her, and then kept going. They didn't bring her into the office with her lawyer, have a chit chat and say, okay, so we're going to charge you with this and you're going to plead to this, and it's all prearranged. This is prearranged. So, to the attorney for the individual, this also means that someone who was on the grand jury, who got a jury summons just like y'all do if you're in the US, already has a lawyer. So the feds had already engaged with this individual enough that by the day they were charged, they already had a criminal attorney. To the attorney, the United States Attorney for the District of Massachusetts and your client agree as follows. Just a girl, we're going to talk about the deal when we get to the end. Change of plea. As soon as practicable. The court date in this case is set for July 22nd. So this could happen on July 22nd. Or sometime right thereafter. Or the plea could happen and then the sentencing could happen later if they need a report. As soon as practicable, the defendant will waive indictment and plead guilty. So they're not going to do a preliminary hearing. They're not going to do a grand jury. They're going to waive their indictment and just plea. So defendant will waive indictment and plead guilty. This is what happened in some of the cases with Matthew Perry's death. To count 1 of the information, criminal contempt, in violation of 18 U.S.C. 401 sub 3. Defendant admits that defendant committed the crime specified in this count and is in fact guilty of it. Penalties. This is not the plea deal. This is advisement of potential penalties. This is the maximum. You have to be advised of the maximum. Defendant faces the following penalties: incarceration for any term of years, which is wild that the judge can just pick. Well, under the federal sentencing guidelines. Supervised release for up to 5 years. 5 years on probation is a really long time. A fine of $250,000, well, up to, unless incarceration is imposed, and a mandatory special assessment of $100. Rule 11C1C plea. In accordance with Rule 11C1C, if the court accepts the plea agreement, the court must include the agreed upon disposition in the judgment, meaning the judge can't take the plea and then sentence to whatever. This is a Rule 11 plea. In the Koberger case, they were talking about whether or not it was a Rule 11 plea at the plea hearing. And the court said this is not a Rule 11 plea, but the plea agreement is for, all. So there's nowhere for the court to go but down, really. But the court advised this is not a Rule 11 plea. We're also seeing that advisement here. It means Rule 11 means the judge agrees that the sentence will be what the plea agreement is. In some cases, especially in federal cases, less depending on the state, the defendant will plea and the court will decide. And the government will make a recommendation and say, Your Honor, we think it's this. And the court can say, I think it's more, I think it's less. I don't have to do what you say. I can do what I want. Emily, where's your Cartman drop?
Respect my authority!
I did what I want. This is a Rule 11 plea. The judge doesn't do what they want. The judge says, if I accept the plea, I'm accepting the plea deal. And if the court doesn't accept the plea deal, then this plea doesn't get taken. Hi, you have an update. Dr. B has an update. Hold on. We've got a theme song for Dr. B. What's the update? I know you can't. What's going on?
Something about the router, the ONTs not playing with the OPP, and
Some bullshit.
well, so some things there's some things that she did immediately to help it.
Okay.
But it cannot be rebooted, and she wants to reboot it.
Oh, it can't be rebooted until I'm done streaming.
No, I told her to reboot now.
Yeah, I know. No, don't. She can't reboot it now.
Yeah, you'll be down for 5 minutes.
Don't fuck with me when I'm live.
Maybe 10.
No.
Maybe 10.
He's messing with you guys. You don't stress me out.
They're gonna reboot. They're gonna reboot the system at 5:30.
Okay.
Because I figure you'd be done by then.
I will definitely be done by then because I do have physical therapy. Thank you.
Okay. All right, so that's it. Yes.
He's like, we'll just reboot it now. Come say that to the law nerds with a straight face. They can't even see your face to know that you're joking. He thinks he's funny.
I told the rep to reboot the system now.
Brian,
I can't twist my head that way and talk. It doesn't work that way.
we're gonna have Dr. B on another members only live, and he can explain himself then. Thanks, Dr. B. Mm-hmm.
Welcome. I'm here to help.
Right. So back to reality. Back to Rule 11. He's like, I can't, and I'm like, they still can't see you. Back to Rule 11. Rule 11 tells the court, hey, you're going to do what we asked you to do? Because if you're not going to do what we asked you to do, don't take the plea. If the court is taking the plea, they're saying if the court is taking the plea, then the sentence is what we agreed to. And if the court is not taking the plea, then we'll just go forward with the case without the court taking the plea, I suppose. The court's not going to do that in this case, unless the court asks for more of a fine. It's possible. In accordance with Rule 11, if the court accepts this plea agreement, the court must include the agreed upon disposition in the judgment. This is an agreed plea and an agreed sentence. If the court rejects any part of this plea agreement, the U.S. attorney may void the agreement or the defendant may withdraw from it. Defendant may not withdraw defendant's plea for any other reason. So if the court says, no, we're fining you $250,000, the defendant can go time out. Not that. The wild abysses. Do you call Dr. B in your normal life or just on stream? No, I will often call him Dr. B. Normally I just call him B. Most of our family calls each other by first initial. I will often call him B because his first and last initial are B. And so I will often just call him B and G and T and E. But I will call him Dr. B if we are out sometimes. Sometimes I'll just say, yes, doctor, if I'm being patronizing, the way somebody would say, like, yes, chef. If I'm just being annoying, I'll be like, yes, doctor. We'll do that. We'll do that right away. And he's just like, but then again, we've been married for 24 years. So the teasing. Let's see. Defendant may withdraw from it. So if the court says, I'm going to fine you a fuck ton of money, the defendant can go, yeah, I didn't agree to that. I'm not doing that. But the defendant can't just like change their mind. Only if the court changes the deal. Should the U.S. attorney void the agreement or the defendant moves to withdraw the defendant's plea, defendant agrees to waive any defenses based on statute of limitations, constitutional protection against pre-indictment delay, speedy trial. Likely not a problem here, but continuing. Sentencing guidelines. Remember, the feds have a whole flowchart of how this works. The parties agree, based on the following calculation, defendant's total offense level under the guidelines is 10. Remember, there's like a whole chart with offense levels. Defendant's base level is 14. Defendant's offense level is decreased by 2 because defendant has accepted responsibility. Defendant's offense level is decreased by 2 because defendant is a 0-point offender, meaning no prior record of anything of substance. I mean, traffic tickets are always possible. That's not going to be part of the issue here. So base level 10 minus 2 minus 2, or base level 14 minus 2 to get us to 10. Defendant, Emily, when you went to law school, they said no math, and then all of it's fucking math. I know. Like, I know. Yeah, I know. Defendant understands that the court is not required to follow this calculation. Defendant also understands that the government will object to any reduction in defendant's sentence. I mean, there's nowhere to reduce it to, like at all. Reduction in defendant's sentence based upon acceptance of responsibility and may be released from the parties' agreed upon disposition in paragraph 5 if A, at sentencing, defendant directly or through counsel indicates the defendant does not fully accept responsibility for having engaged in the conduct underlying each of the elements of the crime to which defendant is pleading guilty, or at the time of sentencing, defendant has committed a new federal or state offense or has in any way obstructed justice. So if you're like, does the defendant have to cooperate? Yeah, they have to cooperate and likely already have. So, yeah, have to cooperate. Nothing in this plea agreement affects the U.S. Attorney's obligation to provide the court and the U.S. Probation Office with accurate and complete information regarding the case. Agreed disposition. This is the plea. The other parts were advisements. This is the plea. The parties agree on the following. Incarceration for 1 day deemed serve. So, 1 credit 1. No fine. 24 months of supervised release. Probation. The probation is going to be cooperate with law enforcement, stay out of trouble. Do you know what cooperate with law enforcement means? Provide us the information that we are asking for, which has probably already been done. If we're like, hey, you need to come testify, do it. A mandatory special assessment, they can't waive that, of $100, which the defendant must pay to the clerk of court on the date of sentencing. What will likely happen here is that when the case goes forward on July 22nd, if the court agrees, the change of plea will be entered. It will be put over for 4 months, plus minus, for a PSR to be done. and then sentencing and probation will start. And that's it. Waiver of appellate rights and challenges to conviction or sentence. Defendant has the right to challenge defendant's conviction and sentence on direct appeal. This means the defendant has the right to ask a higher court to look at what happened in this case if the appeal court finds the trial court or the parties made certain mistakes, overturn defendant's conviction or sentence. In some instances, these are advisements. Defendant has the right to file a separate civil lawsuit claiming that serious mistakes were made in this case and that defendant's conviction or sentence should be overturned. Defendant understands that defendant has these rights, but now gives them up. Advised of rights, waives the rights. Defendant will not challenge defendant's conviction on direct appeal or any other proceeding, including in a separate civil lawsuit, and defendant will not challenge defendant's sentence, including any court orders related to forfeiture, restitution, fines. The fine in this case is $100, which are mandatory fees. Or supervised released on direct appeal or in any other proceeding, including in a separate civil lawsuit. So advisement, waivers. The U.S. attorney agrees not to appeal the imposition of sentence agreed to by the parties in paragraph 5. Defendant understands that by agreeing to the above, defendant is agreeing that defendant's conviction and sentence will be final when the court issues written judgment after the sentencing hearing. After the court issues written judgment, defendant will lose the right to appeal or otherwise challenge the conviction and sentence, regardless of whether defendant later changes their mind, finds new information that would have led defendant to not agree to give up these rights in the first place. Defendant is agreeing to give up these rights in exchange for concessions the U.S. attorney is making in this agreement. The concessions are, you're not getting fined, you're not going to jail. The concessions from the defendant are, I'm waiving my rights and I'm telling you what you want to know. First one in gets the best deal. That's not legal advice. It's just often how the feds work. I mean, the state can work that way too. I complained about it a lot in the Baldwin Rust case. The parties agree that despite giving up these rights, defendant keeps her right to later claim defendant's lawyer rendered ineffective assistance of counsel. Ineffective assistance of counsel. So my lawyer didn't tell me. I think the judge is probably going to say, but you agree that you are satisfied with your attorney? I don't think we'll see this be an issue in this case, given what the deal is. But the defendant is also not waiving the right to later argue that the prosecutor or member of law enforcement engaged in misconduct serious enough to entitle defendant to have the conviction or sentence overturned. Civil liability. This plea agreement does not affect any civil liability, including tax liability defendant has incurred or may later incur due to defendant's criminal conduct, and guilty plea to the charges specified in the paragraph above. Breach of the plea agreement. What happens if you don't do what you're supposed to do? Defendant understands that if defendant breaches any provision of this agreement, violates any condition of the pre-release, or commits any crime following defendant's execution of the plea agreement, defendant cannot rely upon such conduct to withdraw from the plea. Defendant's conduct, however, would give the U.S. attorney the right to be released from the commitments under the agreement and pursue any charges that were or are to be dismissed under this agreement, which isn't happening here. There's no additional charges being dismissed. And to use defendant and any of defendant's statements and any information or materials defendant provided to the government during the investigation or prosecution of the case, even if the parties had entered an earlier written or oral agreement or understanding about the issue. So they get to keep all the information she gave them, no matter what. Who is bound by the plea agreement? This agreement is only between the defendant and the U.S. Attorney for the District of Massachusetts. It does not bind the Attorney General of the United States or any other federal, state, or local prosecuting authorities. Which means if there are other issues, you can still be prosecuted for them. Modifications to the plea agreement. This agreement can be modified or supplemented only in written memorandums signed by both parties through proceedings in open court. If this letter accurately reflects the agreement between the U.S. attorney and the defendant, please have defendant sign and acknowledge the plea agreement below. The U.S. attorney signed acknowledgement of plea agreement. Signed July 14th. Defendant and lawyer. We're going to read the acknowledgement of plea. Signed. I have read this letter and discussed it with my attorney. The letter accurately presents my agreement. Letters move on the page for me on a good day when the fax copy is it's so hard. I've read this letter and discussed it with my attorney. This letter accurately presents my agreement with, it should say represents, but either way, accurately presents my agreement with the United States Attorney's Office for the District of Massachusetts. There are no unwritten agreements between me and the United States Attorney's Office, and no United States government official has made any unwritten promises or representations to me in connection with my guilty plea. I have received no prior offers to resolve this case. I understand the crime I am pleading guilty to and the maximum penalties for that crime. I have discussed the sentencing guidelines with my lawyer, and I understand the sentencing ranges that apply. I am satisfied with my legal representation my lawyer has given me, and we have had enough time to meet and discuss my case. Does this sound familiar? Yes, it's standard. It's standard. The Silverleaf, the line about finances and taxes is standard, so I'm not reading any more into it. I am satisfied with the legal representation my lawyer has given me. We have discussed the charge. We've had enough time. We've discussed possible defenses I might have, which are going to be tough because the most likely scenario is that this is also digitally tracked through emails, messages, etc. So defenses are going to be what I didn't know. That's not going to help. I didn't know is not a defense here. I'm entering into this agreement freely and voluntarily because I am in fact guilty of the offense. I believe this agreement is in my best interest. It's a good agreement. Signed, dated July 14th, 2025. And then the lawyer agreed, signed and dated 2025. So we have gone through the charging document, the plea agreement, and the press release from the United States Attorney's Office. What we know from court documents is that the defendant, Jessica Leslie, was on a Boston federal grand jury and disclosed information from that grand jury, pull this back up, to multiple individuals. The information that was disclosed was the names of various witnesses appearing before the grand jury, the substance of their testimony, and other evidence. Spilled the beans on witnesses, who they were, what they said, and other evidence. This does not specify whether it was one case or multiple. Grand jurors sit on multiple cases. We know that the dates here are alleged to be multiple disclosures between August 1st, 2022 and March 4th, 2024. We also know that the date that this grand juror was given the advisement by the judge is May 26, 2022. We know that they have accepted a plea deal, that they are going to get 2 years of probation. They're going to pay the $100 fine. They're not going to get the fines specified in the law. They're going to get 1 day, serve one, so credit 1 day. But this charge will be on their record. Now, whether this could be expunged later, we don't know. Probably. I mean, it's the type of charge. I would actually have to look to see how they categorize it and whether this would be eligible for expungement down the road. Possibly. This is federal criminal contempt for violating that judge's order. This will be back in court on July 22nd, 2025. It's likely that that date will be the change of plea because this plea agreement's already signed. It's not likely that that will be the sentencing date. Most federal judges want a full report, and those reports take a few months, like 90 days at a minimum. So the questions that loom are, what case or cases? Who was told? How were they told? And how did the feds find out? We're going to go to some of the media reporting on this to see what they have to say about it. I will continue to caution, what we know is what's here. Half Irish says she just blabbed to some girlfriends. We don't know that for a fact. Also, if that was all, the feds wouldn't have found out. There is a way they found out. We're going to talk about it. Will the hearing be live streamed? No. Federal court. It will not be live streamed. But also, the feds will have quite a lot more information from this individual and probably dumped all their devices as well. And we will see. All right, let's go to two of the articles from last night. I'm sure there's more today. I haven't gone and looked this morning because, again, when we cover news that is new, it's going to continue to change. I'm going to try to stop the video from moving in this. Oh my God, I hate embedded video so much. All right, we're going to WCVB first, which is a ABC. And then we are going to go to Boston Globe, I think. My brain just buffered. So, WCVB, grand juror admits to leaking information in Karen Read case. For all of you that are going to say, but the court documents say nothing about the Karen Read case. I agree, they don't. From Boston, we're going immediately to reader mode. Yay, reader mode. My brain just went, okay, now I can read. A woman who served on the grand jury as part of the investigation into Karen Read agreed to plead guilty to a federal charge. She leaked information from the secret proceeding, according to a court document filed Tuesday, ABC News has learned. We covered the document. We covered the press release. The connecting this to the Karen Read case, the media is doing on their own. They go on to say Jessica Leslie agreed to plead guilty to a charge of criminal contempt that accused her of willfully disobeying court orders by releasing the names of various witnesses. That's all in court documents. They go on to say, while the charging document did not specify that Leslie was a grand juror in the Read case, sources confirmed it to ABC. They didn't say how. They didn't say why. Sources confirmed. In June, Read was acquitted on all serious charges connected to the 2022 death of her boyfriend, we know. Leslie agreed to a sentence of incarceration for 1 day, deemed served, no fine, and 24 months of supervised release, court records say. A plea hearing was not immediately scheduled. The first initial appearance is scheduled for July 22nd. It's likely that there will be a change of plea there because at the initial hearing, there would be an arraignment. These are the charges against you. How do you now plea? There's no point in pleading not guilty if you're going to plead guilty. It's likely the change of plea will happen that day. Federal prosecutors did not say how they learned this individual had disclosed secret grand jury information. Sources said authorities had been monitoring social media accounts and other communications during a case that received widespread attention. There are numerous cases that received widespread attention. And I would put a lot more credence into other communications than just social media. I don't doubt that authorities have been monitoring social media. Other communications is more my bet. Yes, social media gets monitored. Other communications would also be monitored. What's on social media is not enough. However, social media companies can be subpoenaed to disclose things. We're going to have to talk about this more in the podcast in connection to other cases. But social media can be subpoenaed to disclose things. So things on social media might trigger a look into things. However, other communications don't surprise me either. The feds have dumped a ton of information in connection with the Read case, but also in connection to the Birchmore case, but also in connection to cases we don't know yet. Remember, the only reason that other Albert at Canton was disciplined is because of the text messages with Proctor. It's the only reason. And then why does it repeat it? I have no idea. Whole story gets repeated twice when I put it in reader mode. I don't know if it's embedded in one of the photos. And so when you put it in reader mode, it says, but it repeats again. It's probably embedded into the video. So ABC is saying that sources confirmed. We'll see. Let's take a look at the Boston Globe article because they detail, well, more of the same. What I will say is this can be the Read case. This can be the Read case plus, but this isn't the Read case that charged Karen Read. Karen Read was not charged by a federal grand jury. Karen Read was charged by a state grand jury. This does not change the charges against Karen Read. This is not necessarily underlying the charges against Karen Read, because the federal grand jury in the Read case was looking into what we think is the investigation in the Read case. And the feds got a lot of phones about that. I see some of you asking me about the Walsh case. That's a state case. I have not seen anything to indicate the feds are involved in that. The cases that I have seen in this time span where the feds are involved are the Birchmore case and the Read case. That doesn't mean there aren't other cases that the feds might have been involved in. We just don't know it. But state level prosecutions are not the issue here. And there was a Birchmore grand jury. There was a Karen Read grand jury. We know those two things because, well, we heard from ARCA, we heard from all the witnesses that testified at a federal grand jury. And we know that there was a federal grand jury in the Birchmore case because we saw the charges come from that. I covered that a while ago when that happened. So the federal grand jury could have heard several cases, not just Karen Read. Correct. Correct. This is from the Boston Globe. Federal officials charge grand juror in Karen Read investigation with leaking information. Again, court information does not leak this grand juror and the leaked information specifically to the Karen Read case. Nikki asked if this is connected to the Read case. Now that she's been acquitted, this leak will not negatively affect her being Read. It wouldn't have either way. The federal grand jury was investigating what we think is the investigation. The federal grand jury was not charging Karen Read with anything and did not charge Karen Read with anything. The federal grand jury was investigating something else. The federal grand jury brought in ARCA to say, could John O'Keefe have been hit by a car? ARCA said no. So the federal grand jury was not and did not charge Karen Read with anything. But the federal grand jury was substantial and ongoing because, as we heard from witnesses, particularly in the first trial, We heard from witness after witness that testified at the other proceeding, the federal grand jury. Sometimes it was the state grand jury. Sometimes it was both. But we saw witness after witness testifying that they went to grand jury in a variety of different months prior to trial number 1. So the federal grand jury was held before 2024. I think they were talking about it in 2023. So, headline from the Boston Globe. Federal officials charge grand juror in Karen Read investigation with leaking information. A Massachusetts woman who sat on a federal grand jury that investigated the state's handling of Karen Read's murder case has been charged with criminal contempt for allegedly leaking information about the secret proceedings. Yes, the person was a grand juror. Yes, they leaked information. Yes, they're pleading guilty. Let's see how the Boston Globe, which is not an ABC company, is connecting this back to Karen Read. Jessica Leslie was charged Friday in federal court in Boston with 1 count of criminal contempt and has agreed to plead guilty, according to an announcement Tuesday by the U.S. Attorney and Ted Docks, special agent.
Survey says
No!
the FBI.
That one. That one. Wrong button. A plea agreement by Leslie Tuesday says the government and defense have agreed to recommend that she be sentenced to 1 day served, meaning she will not spend any time in prison. If the judge adopts the recommendation, a hearing date is yet to be set. This was published maybe before that was on the docket then, because that July 22nd date's on the docket. Leslie is accused of disclosing sealed information about the secret grand jury proceedings between August 11th and March 4th, including the name of various witnesses who appeared at the grand jury and the substance of their testimony. Officials did not disclose that Leslie was sitting on the grand jury hearing evidence about the state prosecution of Read, who was acquitted by jury in June. However, 2 people familiar with the allegations confirmed that she was accused of leaking information related to the Read case. Okay. Take that as you will. Attorney Keith Halpern, who represents Leslie, declined to comment on Tuesday. She has been charged in an information, a federal charging document that signals that the plea agreement has been reached. A change of plea hearing is yet to be scheduled. Yeah, it's going to be at the first appearance on the 22nd. We know about the Read case. There is 1 sentence. Let's see if we get any more sentences. So far, 1 sentence. 2 people familiar with the allegations confirmed she was accused of leaking information related to Read's case. Who? And how did you find them so quickly? How did ABC knew who to talk to? Because that press release was made like in the middle of the day yesterday, and then these headlines started popping up. Whom did you speak to, and how did you speak to them so quickly? I have questions. Let's see. They go on to say, in a highly unusual move, all of this case, in a highly unusual move, the U.S. Attorney's Office convened a grand jury to investigate the state's handling of Read's murder prosecution before the case went to trial. It was the weirdest shit ever. While federal grand jury proceedings are by law secret, details of the probe into the Norfolk District Attorney's prosecution of Read spilled into public view during state court proceedings. Norfolk District Attorney Michael, I've got to put this in reader mode. Literally. Sorry, chat. I was trying to keep the formatting. I literally can't. It's going to take me forever to read it. Norfolk District Attorney Michael Morrissey wrote letters to the Justice Department in 2023 raising concerns about the unprecedented use of federal power to interfere with a state homicide investigation, according to court filings. We have not gone over all of these letters. We might need to. It's been a minute. Also, it's so much easier for me to read. I just feel like I don't stumble over my words as much when I can read on the background color that works for my brain. Federal authorities hired crash reconstruction experts. Oh, yes, they did. Who concluded that O'Keefe's injuries were inconsistent with being struck by a car. That same expert was later called by Reed's defense to testify at her state murder trial. Yes, both Rentschler and Wolf. The federal crash reconstruction report was among some 3,000 pages of documents, including grand jury statements by witnesses that the U.S. Attorney's Office turned over to Reed's lawyers and state prosecutors prior to her first trial. The U.S. Attorney's Office, I wish they just had the day of that. Because it was I think it was right around that March timeframe based on everything, but so much has happened. The U.S. Attorney's Office and the FBI, who?
The FBI!
Declined to comment on the federal investigation. Yeah, no shit. However, it was disclosed during state court proceedings in Reed's case that all of the people who were inside the Alberts home around the time of O'Keefe's death were subpoenaed to testify before the federal grand jury. In March, state prosecutors revealed during pretrial proceedings in Reed's murder case that the federal grand jury investigation into the state's handling of her case was closed. They added some words into that sentence. What Brennan said was that the federal investigation was closed. They said here that the federal grand jury investigation was closed. Those are two different things. 100% two different things. Because the grand jury can conclude while the investigation remains open. In March, state prosecutors revealed during pretrial proceedings in Reed's murder case that the federal grand jury investigation into the state's handling of her case was closed. Until now, federal prosecutors have not pursued any charges related to the Reed case. They are also saying that this is part of the Reed case. Zimmy, I have it set in bionic reading mode because it's easier for my brain to read. It's particularly helpful for folks who are dyslexic or have other visual processing stuff. I have all of it. So I actually don't see the letters as different. It's just easier for me to read, but I don't see the difference between the letters. But I know for some of you, it's like this, some of you, this lettering makes your brain hurt. And some of you are like, oh, I can read. Alley Cat, I'm not saying Brennan misrepresented something. I'm saying that there is a difference between what the media is saying and what Brennan is saying, and it is not a difference without a distinction. It is actually a noted difference. And the noted difference is a grand jury can conclude, but the investigation can still be moving on. So it really depends. So again, I'm not saying Brennan did or didn't. I'm just saying two things, or both. I mean, it could be true that the federal investigation is completely closed and the grand jury has wrapped up. Both of those things can be true. I mean, the grand jury would not be ongoing. We need like the Venn diagram. The grand jury would not still be going if the investigation was closed, but the grand jury can be done and the investigation still be open. So what do we know? We know that the media is saying that this is connected to Karen Reed's case. And with the timing of these charges, not when they're brought, but the time span, it covers the time span that Karen Reed's case was before the federal grand jury. It also covers the time span that other cases were before the federal grand jury. Because, hold on, let me grab my file real quick. I just want to look at the date of the indictment in the Birchmore case, because I don't remember off the top of my head. The Birchmore indictment came down August 27th, 2024. So, I mean, it's possible that the Birchmore grand jury only took a few days and that didn't happen until August of 2024. So it's possible this person was no longer on a grand jury when the Birchmore grand jury was convened. That's possible because this indictment wasn't done until August 27, 2024. And the charges here are for a grand jury that was, let's pull that back up. The charges here are for a grand jury that was going on at least around May 26, 2022. Here is what I will note on the timing of that. Karen Reed's second indictment when she was charged with murder was June of 2022. I don't know if this individual would still be on a grand jury when the federal grand jury convened looking into the Karen Reed case, even though sources say that it was. Because the Karen Reed grand jury, to the best of my memory, was going on in 2023 based on all the witnesses that came in and said I testified in 2023 at that prior proceeding. However, people can serve a full year on a grand jury serving 1 or 2 days a month. And grand juries can be ongoing. This date is when that admonishment was given. Though it would be repeated, this date might be when, and most likely is when, the individuals started grand jury service. They could have been on a grand jury from May 26, 2022 to May 26, 2023 or beyond, just depending. Rose said, why isn't there a list of grand jury hearings in Massachusetts on the internet? Because it's secret. So it's all sealed. You will never find a list of grand jury proceedings. And if you do, it's not real. So the information was shared between August 11th, 2022 and March 4th, 2024. The grand jury would have been convened that this person sat on or after May 26, 2022. We are seeing lots of information that this is connected to the Karen Reed federal investigation with the ARCA witnesses. That may be true. That may not be true. It may be connected to multiple cases. That may also be true. So we are going to have to wait and see. Because we are going to get maybe more information about this, maybe not. But it could also be more than one case in that amount of time. It really can. And there were people rumbling about what happened in the Karen Reed grand jury before the Fed dump in the case. That still doesn't let us know who this information was given to. We don't know who this information was given to. This could be information given to anyone. And we have not seen those sources disclose that they were individuals that the information was given to. So, what we know for sure is that the defendant is from Massachusetts, sat on a federal grand jury. Grand juries cover numerous cases, not just one. They were advised that grand jury proceedings are secret and sealed, and that they are not to disclose that information to anyone. Between August 11th, 2022 and March 4th, 2025, double checking, it says 2025, no, 2024, March 4th, 2024, on numerous occasions, this individual disclosed the names of witnesses, the substance of their testimony, and other evidence that was disclosed to a grand jury. To individuals, so more than one person. The feds found out about it. They charged them with criminal contempt, contemporaneously offered a plea deal. That means that There were ongoing conversations before this was charged. This didn't come out of the blue for this individual. They probably got a target letter and they were probably asked to cooperate. Do we know that? No. But generally how process works. When you come in and a plea deal is already ready for you by the time you're charged, it's likely that they gave more information to the feds. It's likely that they cooperated with cell phone dump, email dump, etc. So from there, I think the only way we will see this coming up is if the information released never became public and it impacts a third party and they sue over it. It is my suspicion that this was likely tipped off by either communications. It's possible that social media made them look more deeply into it. We know the feds monitor all things on social media, but it's possible that communications that were dumped are what did this. So, would I be surprised if this was regarding multiple cases? Not at all. I wouldn't be surprised, because if one person's sitting on a grand jury and spilling the tea on something, I wouldn't be surprised if they're spilling the tea on more than one thing. There are plenty of ways that the feds dump people's phones and then stumble into stuff that they didn't know. Shelly in the chat said that's how we got Proctor's phone info. Proctor's phone info and personal phone came out of the federal investigation. Yeah, absolutely. So it is just as likely that this was found coincidental to something else as it is that this was found because of social media. And I'm not going to give one more weight over the other, because we don't know. The media 100% is running down the path of this is the Karen Read case. It's possible. It's possible that it's not. And it's possible that it's this and. So those are my cautions. What does that mean for Karen Read? Well, not much. Unless the information was going to Karen Read, I guess. And then, well, even then, what would Karen Read do with that information? And having that information is not the problem. Telling that information is the problem. So who else could have gotten this information? Well, anyone. Also, when people say shit on social media, because we saw that, what case did we saw it in the Depp Heard case where somebody was pretending to be a juror online. We saw another case where somebody was pretending to be a juror and it had to come up. It might have been Waukesha. It might have been the Brooks case, where somebody was online pretending to be a juror and wasn't. I mean, that's not uncommon these days that somebody makes a threat and says they're a juror and they're absolutely not. The Brooks case. Those are the two I remember off the top of my head. So people pretending to have information they don't have is not uncommon on social media, which is why I kind of wait until we see multiple reports on it. And once we had ABC and Boston Globe reporting on this, that both claim independent sources, could those sources be the same one? Yes. The sources could 100% be the same source. But we will continue to see. Does this impact the Karen Read case in any way? It could, but not in the outcome to Karen Read. But if this information was going to like friends and family, it's one thing. If this information was going to anyone who had a duty to the court, that could be another thing. Because generally, having the information is not the issue. Being told the thing's not the problem, unless you have a duty to report that. Telling the thing is what is forestalled by court order. Could we see more from this? Could we not see more from this? Maybe. Maybe. So my caution is, I'm curious to see where this goes. This will be in court the 22nd. I think there will be a change of plea that day. I don't know if we will see anyone else making statements about this who are involved in the state level Karen Read case. I'll be interested if they do, and I will keep an eye for it. Because it's really hard to know from sources who sources are. Really hard to know. Let's see. A lot of other outlets, mostly ABC, are picking this up. And yeah, and that's what I continue to see, is other outlets kind of reporting the same thing. Let's see. Boston.com has picked this up with their own reporting. I wonder if they also have sources. Let's take a look. I'm not quite sure which media family Boston.com is a part of. We can always look in a minute. But let's pull this up real quick. Let's look at one more. So this is coming from this morning, 11:04 a.m. Federal grand juror in Karen Read case to plead guilty to leaking information. The Boston woman has agreed to plead the Dracula. That's going to get confusing if people are listening in the background. Agreed to plead guilty to leaking information about secretive grand jury proceedings, prosecutors said. They did say that in their press release. Let's see. The defendant charged with leaking information from the federal grand jury investigation was reportedly one of the jurors who probed the state's handling of the Karen Read case. That doesn't even help. Reportedly. Other media outlets say their sources said. It's just becoming a game of telephone. We know that she was charged. We know it's in court documents. While prosecutors have not publicly specified the grand jury proceedings in question, the Boston Globe reported that two people, quote, familiar with the allegations confirmed. ABC News separately confirmed that Leslie was a federal grand juror in the Read matter, also citing unnamed sources. So, you guys have a fuck ton of questions. So we're going to get to questions. Donna Adelson's just going to have to wait till another day. Here's where we're at with Donna Adelson. Let's give it a 30-second here's where we're at with Donna Adelson, and we'll get to Donna Adelson in a week or two. Donna Adelson's trial still seems to be on track to start with opening statements towards the end of August, around August 25th. The court has reserved ruling on a motion to change venue. So if they start trying to pick a jury and it becomes impossible, they might still move the venue. So trials still might not start. If they start getting back jury information and the jurors are like, oh, we all know about this case, they might still change venue. That is still pending. Donna Adelson was just in court on other motions. We're going to watch that hearing together. Probably not next week, because next week we're going to be doing the Koberger plea. So, yeah, it'll probably be the week after. Trial still looks like a go. Nothing earth-shattering has happened. Trial still looks like a go. That's where we're at with Donna. Let's get to questions. Let's see. I'm going to hold on to some of these questions because you guys have lots and lots of questions. My goal is always to clear up questions and remind everyone of what we know, what we can surmise, and what is just unknown. And when I say surmise, I think it's the feds are not going to say, oh, we pre-negotiated this plea deal. The timing let us know that that's exactly what happened, and we know that that happens. That is exactly what happened. That is not a leap. But exactly what case, this is all relying on unnamed sources. If it was more than one case, 100% possible. Because if a person's chatting about a case, but there are multiple high-profile cases going on, well, wouldn't they talk about all of them? Right? Let's get to questions. I'm still grabbing them out of the chat. So we need to, by the end of this year, we're going to update the bumper. Peapot Fairy said Koberger coverage all week. Well, Tuesday, we have a bunch of stuff to talk about before the plea hearing. And then Wednesday is going to be an all-day plea hearing. And the plea hearing might go into Thursday. So I don't really know. And if the plea hearing doesn't go into Thursday, we'll see what happens. But I can't promise because I just don't know. I also imagine that from the plea hearing on Wednesday, there will be other things to talk about. The amount of questions I get about whether or not Brian Koberger is actually going to do life or if he's going to get parole is still high. But the law nerds all know what the case law says. So, and then I'm going to be traveling again because it's that time in the DCI season. So then I'm going to be traveling again. So who knows what's going to happen then? As Tucker asked, is a press conference from the feds normal for a charge like this? In high-profile cases, sometimes they'll do a press conference. I only saw a press release. I don't expect a press conference unless one is like currently scheduled. But a press release doesn't surprise me. Why doesn't a press release surprise me? This is the kind of behavior the feds want the public to know not to do. Don't do this shit. And whatever information they want from Jessica Leslie, they would have gotten before they made this public. Because they get to choose when they make this public. Because the allegation is that the conversations stopped in March 2024, more than a year ago. So seemingly when some of the federal information became public, because then also it becomes a little harder to say if information is coming from a secret grand jury. Once some of those Fed doc dumps got to the defense and the prosecution, some of that information is no longer sealed because it's been given to the defense and the prosecution. So then it gets a little harder to say this was sealed versus, well, this was in court documents, because then the defense and the prosecution started filing things in the Karen Read public case that we started seeing, where we started hearing about the federal investigation and more about the federal investigation. And then the motions for witnesses and stuff leading up to the first trial. So I wouldn't expect a press conference. The press release doesn't surprise me. And I'm going to grab, I saw another comment that I wanted to, or question that I wanted to grab. Because they want the public to know that this shit's not okay and that they go after it. They want people on grand juries to be like, shit, I don't want to get charged, fined, dragged in and questioned by the feds about any of this. So yeah, in this case, a press conference, maybe not, but a press statement like we saw the press release, yes. Lona said it's impressive the feds even found out. Well, if people are talking, they're talking, aren't they? It's whose communications they grabbed first is what I'm curious about. On that, well, most of the topics are going to be about that today. But let's see. Jay Ford said, question, why do you call it a change of plea hearing? Has a not guilty plea already been done? Thanks. A not guilty plea has not already been entered. The first appearance or arraignment can also be called a arraignment, but also change of plea. But Colloquially, I think both are fine. Technically, the first appearance is scheduled for the first appearance. I think that's when they will enter their guilty plea instead of a not guilty plea. But do I call it a change of plea interchangeably? Yes, because it's not a sentencing. It is a plea. So that's why I refer to it as change of plea. But no plea has been entered in the Boston case yet. And I just think a guilty plea will be entered. If that helps. Let's see. Kyle said, from what little I know about grand juries, it's possible both are true, but not associated. Karen Reed's case would have been heard then, but so were many others. It seems to me this would cover that time span, but yes. And cases that we don't know about. The media has said it was a high profile case. We don't know. Nikki said, how long are plea hearings usually? I don't think we can generalize when it comes to the Kohberger case. One of the things in the Kohberger case that is going to, well, plea hearings are normally like 10 minutes, depending on the case. The Kohberger one was actually a little long. The judge would read this plea waiver and advisement and say, how do you now plea? So plea hearings can be quite quick, depending on the advisements and depending on the structure of the plea deal. The Kohberger plea took a little bit longer because the prosecution read in the whole factual basis, and Kohberger gave the plea on each of the elements, but they can be pretty quick. Sam said, when is the Kohberger plea? Next week on the 23rd. LJ Peach said, are they going to lift the gag order before sentencing? That hearing's tomorrow. I think it'll get lifted tomorrow. That's my supposition. I think it'll get lifted then. So that. Eve, why would he ever get parole? He won't. The media has been reporting it. The law nerds have let me know that there are some people saying that that is the case. It's just not accurate. And so people have reported it, and then people get stressed. So I try to ground in that fixed life means it is a life sentence for the length of your natural life. So if there is not a death certificate, you have not served your life sentence yet. So there is not parole. He would not get parole. There seems to be confusion. Mildred said, wouldn't it be his sentencing? He already pled. If I didn't say his sentencing, if I said plea on Kohberger, it's just my brain conflating shit. I apologize. But no, it's his sentencing hearing on the 23rd. My brain will do that sometimes. Rain said, are we watching the Kohberger thing tomorrow? I'm going to record it. It's probably going to be pretty quick. It's on Zoom. I can tell you how it's going to go. The media is going to say, Your Honor, you have our moving papers. And the court is going to say, which we've read. And the court is going to say, is there anything additional? And the media is going to say no. And then the court is going to say something along the line of, okay. Let's see. If there is order sealing exhibit to the state's response to defendant's supplemental request for discovery, state's response. So other stuff is getting put on the Kohberger docket, but the state hasn't responded in writing to the non-dissemination order because the state doesn't have really any legal grounds for that. The legal grounds that the non-dissemination order are based on, and we read through all of that, is the defendant's rights to a fair and impartial jury. That right is gone because the defendant has pled guilty, so no more jury, no appeal. So the court is going to say, are there any objections? The government's probably going to say none beyond what we've already said. And then the court's going to say, fine, I am lifting my order on the non-dissemination order. Is there anything else we need to discuss? No. Great. That's how I expect that hearing will go, but I'll be on a plane. So if there is anything dramatic that pops off, I'll let you know when I get off the plane, or if my Delta Wi-Fi hangs in there, I'll let you know then. But it's going to be the media coalition submitting on their moving papers and the court going, yeah, that's what I thought too. So that's it. Don't worry about that. It's not a big deal. Let's see. More questions. Steed says, I'm not American and I don't understand your grand juries. Does this mean they can overturn Reed's trial? Steed, it is not your fault. You don't need to explain that you are not American, because even a lot of Americans don't understand our jury and legal system, because there are a whole bunch of them and it gets really fucking confusing. So you're not on the back foot. Don't need to apologize for asking the question. No, this has nothing to do with Reed's trial. Here's why I wanted to answer your question, though. Reed was largely acquitted. They cannot overturn an acquittal in the United States. So if Reed is acquitted and then more evidence comes out showing that Reed, I don't want to use this case because this case is so contentious. Hypothetical case. The Hamburglar burgles hamburgers and then is acquitted because, well, the circumstantial evidence was just not there and nothing showed that the Hamburglar actually burgled or broke into anything or whatever, but they went to trial anyway because who knows, they went to trial anyway. And they went to trial anyway, and he was acquitted of hamburgling the hamburgers. And then a video came out showing him doing all of the things. There is nothing that can be done if he has already been tried for that case, because double jeopardy and because of the acquittal. The acquittal is absolute. It doesn't matter what comes out later. The acquittal is absolute. So in the US, and this is not true everywhere, but in the US, acquittals are absolute. If you are acquitted, you are done. The movie Double Jeopardy with Ashley Judd is actually really helpful on this point. Of law movies, it's actually a really good movie. Now, if the video is of a totally different date that the Hamburglar was not tried for and that law enforcement did not know about, then he can be tried separately about that different date. But if it was something, this gets very complex quickly, but if it was something that the law enforcement and prosecution knew about at the time they prosecuted but chose not to prosecute it, then double jeopardy still applies, and then we get into law school. But acquittals can't be fucked with. They're just done. So if somebody's acquitted and the prosecution's like, yeah, but the defense did all this shit, too bad, so sad, you don't get to appeal. You don't get to appeal. But what if the defense, doesn't matter, if it's an acquittal, you don't get to appeal, done. The end. Snazzy Shazzy, and many of you in the chat asked, is this how the phones got rehomed? No. This is not how the phones got rehomed. For those of you that did not watch the Reed first trial, there was testimony from Brian Albert, homeowner, Brian Higgins, ATF agent, who did not rehome the dog. Emily, it's not the time to make ATF dog jokes. Yes. It's not the time. It's not the time. What was happening in state court running up to their personal phones being upgraded was requests for those phones. Remember, court process. And there's a lot of court process. So with court process, the state court was going through the motions to get their phones. But the order had not been made yet, which is a failing in my opinion, to preserve the phones. And so the phones, poof, before the preservation order came down, but it's because there were state proceedings going on. They were aware of those state proceedings. Those are public proceedings. They were aware that the defense was seeking their phones. They were aware, I'm sure, that a preservation order was likely. The phones were gone the day before the preservation order came down. So there was state process heads up directly connected in time. A lot of you asked, Julie and many others, about talking to therapists about grand juries. This could vary by state, and it is something that if someone was a grand juror in a grand jury that was secret and sealed, that they wanted to talk to their therapist about, that they would probably ask their therapist, can I talk to you about this? Because therapy relationships are confidential, and the guidance on that, I think state by state would best come from the treatment provider because those are confidential relationships. But they are told to not disclose to anyone. Now, I think there would also be a way to talk about cases in a therapeutic setting where you are not disclosing the name of the person, the identity of the witnesses, and talking about the things that are difficult to process without disclosing some of that information. But that would be a conversation to have state by state with a treatment provider, because I think there would be ways to discuss what's difficult in a therapeutic way without disclosing private information. And you can also ask the court, hey, this shit's really hard to process. Can I speak to my therapist about it? And the court will generally say yes, because that is a protected relationship. And therapists also know the boundaries of those things. So that's what I would advise on that. Look, if you are in a situation where you want to talk to a treatment provider and you have a confidential relationship, it's always okay to ask. It's always okay to ask. And your treatment provider can find you ways to talk about it. Hold on, I'm going to pull this up. This is really good information from Lithy. During my grand jury service, I asked if I could speak to my therapist. I was instructed I could speak about my feelings, my emotions, and not discuss details of the case. Yeah. And a provider would know that, which is helpful. So, Kaiser Wilhelm, grand jury service should be public after a person is charged. What happens at the grand jury is not public after the person is charged. So, I think there's a lot of reasons for that. So, but it is not. The trial will go forward and defense attorneys will have information on it. And when defense attorneys have the information on it, they can take that forward if there are issues. We saw that in the Koberger case. We saw lots of motions to try to get the grand jury thrown out. But the standard that the grand jury has to find is a very low criminal standard. It is the same standard that you find at a preliminary hearing. So probable cause is a very low standard. And whether it's a grand jury or a preliminary hearing, it's a very low standard. Brandon said, I have questions, all the questions. I still have questions. EDB was like, I don't need sleep. I need answers. True. And I want more. Cosmic PR said, congrats to the Cavaliers. Go Travis. He had a great show last night. The Cavaliers pulled in a little upwards of an 82 last night. It was very exciting. That was not streamed, but the Lawnards that were there reported back. I love that you guys got to go meet up in person and do in-person things and go see marching band. It was fantastic. Rebecca gifted 5 memberships. Thank you. Welcome new members. There are some members onlys with Dr. B and I. You can go find them and see the nonsense. Tina K.S. Leonard, thank you for the gifted memberships. Much appreciated. Mega pint coffee cups needed. True. True. Vasilette said, did think the Brooks trial was as crazy pants as it would get. Was wrong. The Brooks trial, Brooks had his own way of interacting with the world. But the prosecution in the Brooks case was incredibly diligent and incredibly mindful. The court at times I was critical of because I thought that the court gave Brooks a little bit too much leeway. The court can handle things the way the court wants to. But the court handled things sometimes with maybe too much leeway. I was like, stop letting him do the things. But the court was incredibly patient. And so it's really not fair of me to be critical of someone's patience, but also we were just like, no, stop it. Throw down the hammer. But the court process, Brooks himself was a whole wild component to that case, but the court process itself went through really normally. All the lawyers acted normal. The judge was maybe more patient than normal. But it was wild because of Brooks. What I really appreciated, the Brooks case is heartbreaking, which is why I didn't cover a ton of the prosecution side of the case. I can't even talk about some of it. It's just, nope. What was encouraging from the Brooks case is, one, the prosecutors went out of their way to make sure they were protecting the defendant's rights in light of everything the defendant did, which is exactly what the job is, and in light of how wild the defendant was being. I think the prosecution went above and beyond to make sure that they were never pushing even close to where a defense attorney would object. They kept it so incredibly neutral for Brooks, and I think they did an incredible job acting as prosecutors while also thinking of the defense and really being mindful of all of the defendant's rights and protecting those and playing both offense and defense all at once. I also was incredibly encouraged by all of the families and victim families that spoke at sentencing. It was a heartbreaking sentencing hearing. Absolutely heartbreaking sentencing. But how much the victims and the victim families and the witnesses felt supported by their district attorney's office, supported by victim witness assistants, and supported by their emotional support pup. I thought it was tremendous to see. I like to see cases that proceed where everyone's doing their job. This case has been so wild, the Read case. And there are times when I'm just like, what is even happening? This never happens. How many times in the Read case have I said this never happens? But in spite of Brooks being incredibly difficult as a defendant and as a self-represented defendant, the rest of the things proceeded as they should. A couple of you asked, Emily, have you dealt with pro pers? I've dealt with pro pers. I've dealt with soft sits. I've never done a case that long with a pro per, or that was a homicide case with a pro per. That's a whole different thing. Katie said, loved watching T last night. The Cavaliers were amazing. Thank you, Katie. You need to put Dallas Cowboys colors on your nails. Rebecca, thank you. I have Cavalier shapeshift on the nails, and that's what we're doing. Casey Cat said, great law nerd meetup at DCI with Kathy at Oz, Cosmic PR, Red Hot, Amy Kate, and Julie. Travis and the Cavaliers won. I know. I love that you guys went to go see it. Like in real life. It's so different. It's great to watch streamed or in the movie theater. It is something else when like the horn line all picks up and then blows your face off. You're just like, yes. Every DCI show I watch, and for those, the international law nerds, I will use DCI and marching band interchangeably because, well, DCI refers to itself as the Major Leagues of Marching Band. And so Drum Corps International, it's like marching band. There's an account on Instagram called DCI Pickle that starts all of the DCI videos with what the fuck is. Like, what the fuck is DCI? It's marching band, but rip out the woodwinds and make it insane and set the beats per minute to all. And then instead of the halftime show being a few minutes, make it 12 minutes. So when they say it's like Olympic level marching band. And so it is loud and amazing. And the shows are all themed to the costumes, the performance, the marching on the field, the props that they use, the color guard uniforms, all the rest of it. It is incredibly themed. So it is visual. It is visual arts and Olympic level, like athleticism all in once. I mean, they train the way you would see athletes training because they have to, because otherwise they will fuck themselves up. And even when they train that much, they still fuck themselves up with foot injuries, heat-related injuries, overuse injuries. And when you're looking at the instruments, they are running on field. I mean, the drummers have to keep hands in time and not like fall over backwards or like roll an ankle sideways and march and make it look good and be in time while they're running across a football field. The other instruments still have to blow through a fucking instrument while running around a football field in time, like right next to someone else, while the guard is yeeting things into the air over them, sometimes very close to them, other times, and they don't get to flinch. It's wild. We'll do another take a look at DCI show, but it's insane. And dude, I was watching Crown last night. Brian Allman said, I know nothing about DCI, but the reels of Carolina Crown's horn line warming up are absolutely amazing. They do call themselves God's horn line. Unless that was the name deemed to them. Tony, let me know how Carolina Crown started to be called God's horn line. But Crown performed at Coachella this year, their horn line. They've snapped some of their field shapes in such an insane way. Like Carolina Crown makes the Carolina Crown logo on the field and you're just like, oh shit. Some of the movements last night from Bluecoats were so fucking fast. I was like, they are not moving across the field. They are fucking sprinting across the field with horns up and music coming out. It's insane. It's just so fast. But as we're getting towards the end of the season, the pageantry is all starting to come together. It's so good. I love it all. Emily, how do you respond to music live? I yell and then I generally cry. I get overexcited. And I'm just like, I don't know why I'm crying. I'm so happy. So I love it. Ellie said, have you ever had a gag order in a case that I personally prosecuted? No. However, when cases that I prosecuted ended up in the media, I can tell you exactly how that went. Hi, DDA Baker. This is so-and-so from media. Hi, media. This is DDA Baker. Yes, we were in court today. The phone number for media relations is 213 blah, 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 blah. They'll be happy to update you on the case. Their email is blah, blah, blah at la.da.ca.gov.com. Whatever. They'll be happy to help you. Thanks. Click. Every single case. Yes, this is DA Baker. Yes, we did have court today. The phone number for media relations is. I was in court once when I was with co-counsel in a case, who was the lead attorney. And someone was chasing us in the courthouse. Chasing us to try to catch up with us and get a statement on a case. And we both looked at them. We're like, okay, no need to run. The number for media relations is. They're on the 9th floor of this building. No, they weren't on the 9th floor. I don't remember we were on the 9th floor. I don't remember what floor they were on. We're like, media relations is on whatever floor. You can go talk to them. We have no comment. Literally chasing us down the hallway. You don't need to run. Go talk to media relations. That's how all of that went. So no, I didn't talk about my cases. Unless there were statements that victims' families wanted to put out when the case was done, then I provided those to media relations, and that was it. So, Moo Boy Moo said, question, did you see they cast the Legend of Zelda movie? Can we react to that for fun? I did not see that they cast it. I am the worst person to do movie cast reactions because, again, I'm just like, okay, I guess that's fine. But I will take a look at it. That sounds very members only live. So let's see. I am Nishay. I didn't know you did concert band. Alto sax. Octo is also a sax player. It's really funny because DCI is one of those things that's like any other. A lot of you have very specific interests. I love this about all of you. I love this for all of us. But if you are particularly knowledgeable in an area or have a deep love of an area, sometimes it's hard to have casual, maybe this is a neurospicy thing. Maybe, I don't know. It's really hard to have a casual conversation sometimes. And so often you will suss out the level of someone else's interest. I don't always do this, but before you just like bleh onto them about all the things. So when we went to these last Dave Matthews concerts in Charleston with some of my Dave friends, a newer Dave friend who enjoys the music but has not been to a ton of concerts, but is one of my favorite people to spend time with, and OG ride or die, the first day she started working at the courthouse I worked at, somebody looked at me and looked at her and went, y'all are both Dave Matthews fans. And we were just like, what up, homie? Did we just become best friends? And have been going to concerts since that day. So there is a couple next to us that's kind of bopping along. And they're like, we're so excited for Dave. We're like, oh my God, us too. This is like my 68th Dave show or whatever. 67, 68. I know it's on my 69th show yet because I've got that on my DMB hub tracker. And so I'm like, how many concerts have y'all been to? And guy next to me is like, oh, it's her first concert. It's like my second concert. I'm like, okay. We are massive nerds. We don't want to nerd at you too hard. So let us know what level of information you would like. If you would like to know if he's ever played this song as an opener at this venue, we can tell you. If you would like to know when his guitar switches, what song we think it is, we can let you know. If you would like us to scream the title of the song, which we might do anyway, even without your permission, the second the first two chords hit, we will do that too. If you want to know what songs we want to hear, I will tell you, because I've not gotten to see Rashawn Ross, the trumpet player for the Dave Matthews Band. You know, no big deal. Hall of Fame trumpet player. There aren't that many of them. All trumpet players think they should be in the Hall of Fame. If you know a trumpet player, you know that what I'm saying is true, but there aren't that many of them in the Rock and Roll Hall of Fame. Anyway, I wanted to see Rashawn sing Word Up because I haven't seen it yet. And Word Up was great. And I was explaining that they were covering Word Up this year and blah, 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 blah. But I need to know what level of my level of enthusiasm you need. DCI is also one of those things where it's like, how familiar are you with the band world? And if people are familiar with DCI, then you just kind of wiggle and go, oh my God, we can nerd all out. And if people are like, oh my God, no, I enjoyed marching band in high school, you can nerd. And if people are like, is that like the Drumline movie, which there is no shade to, then you have a level of knowledge to work with. And be like, okay, so sort of, but less like riff-offs and more pageantry. More pageantry. More energy. And way more dancing. So you always have to find that level of like, how much do you know about this thing? When I was flying, one of the last times, we were stuck on the tarmac for 100 fucking years, it felt like, because there were planes parked in our spot. And so we rolled in at our normally appointed time and there's planes just fucking parked in our spot. I can't imagine how frustrated the outbound flight must have been because they're all in the terminal looking at our plane and we're all on our plane looking at the terminal and there's just another fucking plane sitting in our spot. They couldn't take off yet. So we couldn't take off yet. So we're all just sitting there waiting. And the gentleman next to and I were chatting and he was heading into Nashville for a conference and blah, 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 blah. And I was talking about things I enjoyed in Nashville. And we were talking briefly about going to Dave Matthews. And he's like, you enjoy live music? I'm like, oh, I enjoy all the kinds of live music. Nashville's great for live music. It's fantastic. Go for it. We started talking about other live music. I said, one of the fun things I get to do this summer, because we were talking about his work travel. And he was like, yeah, my kiddo's gotten more active in things. So I've tried to reduce my work travel because kiddo activity levels. Kiddo was younger than both of my kids. And I'm like, oh yeah. Yeah, I get that. And once the kids start getting real busy with activities, depending on the level of like Are we talking like travel, club soccer? Like what level of activity are we talking? It can get insane. And I said, I get it. My kiddo does marching band and like competitive marching band. So during the football season, it's like band, late nights, competitions and whatever. And then he's doing that this summer. He goes, oh, is he doing DCI? And I was like, hi, friend. Yes. Yes, I can. So then we started chatting. He had marched for Phantom Regiment and had been connected to a lot of instructors in the band world. And then we had the most delightful conversation of like nerd. And then I was like, okay, these are the good restaurant recommendations. So it was fun. Stuck on a plane. Emily, will you chat with anyone? Law nerds, are you shocked? So then we started talking about his time with DCI and the difference between doing the thing yourself. Like when my friends were saying, peace out, bitches, and like boarding up on a bus for the entire summer, I was like, oh my God, that's fucking amazing. Just the whole summer, you're just gone. And this was, I can't even fucking imagine, but this was the 90s. So when they boarded up a bus and like took off for the summer, like their parents weren't sitting at home being like, what state are you in? Their parents were like, okay, just call once a month and we'll pick you up in 3 months. See ya? I don't even know how that worked. Bye. So that would be incredibly stressful. And as, again, a teen, I was just like, this is amazing. Have the best time. Like, peace. And now I'm just like dropping off my kid. I'm like, if you turn off location, I will assume that you're dead. So I will arrive at wherever you are. So do not turn off your location tracking because I will not be okay. I will absolutely lose my shit. So stop it. Don't do that. And check in every couple days. So T has been really good about that. And again, what's really nice is with social media, the Cavaliers and Cavaliers Guard on social post pictures. So I get to see them, and be like, oh, proof of life. Great. We called home weekly call collect. I know. It's wild. It's wild. Well, Smurfana, I know. As the kids are doing the things. It's wild. Simone said, what is DCI's cadence like? I don't remember. I do know this, but I don't remember what their literal like BPM is. It's fairly high. Chat will probably be able to tell you because it's freaking fast. If you mean their tour cadence, they do over 10,000 miles, and not nearly enough sleep in between. I'm going to answer some more questions. And then we're going to yeet because then I have to go to physical therapy to see what's going on with my knee. Tracy, I will look into this because I don't know if it's the grand juror, someone purporting to be the grand juror, someone who knew the grand juror, but I will look into it. Valerie said, I got questions shirt yesterday. Those are still in the store. We are looking at stock on what we can stock, but the t-shirt for I Have Questions is still in the store. They are super soft. So if you guys are interested, those are in the Law Nerd shop. So are I don't have them in my office because I was drinking them yesterday. If you look at my Instagram, you will see the koozies. I love them. Elizabeth Ann, marching band and musical theater had a baby. It's very, plus track and field. Amina in the city said, I marched DCI color guard when I was in high school, and I still think about how beautiful Phantom Regiment's color guard was. They really are. They really are. Still are. It's incredible. And there are some bands that have their different like swag that like, this band for this. The thing I love in every DCI show, there is a moment in every show where you see all the horns snap up and then the sound just blows your face off and it's amazing. And you feel like, well, if you're me, you're in that old THX advertisement where they just tune up the bass and you're just like, yes, that's what it feels every single time. Just horns up. I love when you see all those bells go up. Ooh, bitch. It's so good. I get so excited. I can't wait to go see live music. I can't wait. Have you ever done one of those CrimeCon cruises? No, I did CrimeCon the one time. Yeah, no. Disney cruise, yes. You need a Leonard cruise at some point. Patrick said DCI appreciation post. Phantom Regiment. I didn't do it nearly as much or as well as the Branch Cocker voice, but it's the only way to say it. You have to yell Phantom Regiment. Also, can somebody explain to me, because I don't know, I'm going to ask as we travel. Phantom doesn't ask this time, is your core ready for the show with no name? They don't ask at all. Shannon, I loved meeting you at CrimeCon. I loved meeting everyone at CrimeCon. I loved the community that was there. I love the people that I met. There, as a creator, tries to be very mindful of the space, CrimeCon I felt was very geared towards legacy media with preference to legacy media. But it was great to see all the people. But the thing that makes me nervous about anything like that is when I go, that there are plenty of Lawnards that are like, oh, I'll pay for a ticket to go because I want to run into you. And that I didn't feel good about. So we'll just find, we are working on finding our own shit. FL fan, yes, I was in Los Angeles the night that the band announced that Leroy had passed away. It was tough, but it was also great to be with the band. I don't know how they performed. The professionalism was absolutely incredible. Alexa said, thank you for the DCI pickle Instagram tip. Diving into multi-core pillow fight lore now. It's funny. Texas forever. I'm sure the chat will let you know. And if you see me, holler. If they only had piano for marching band, early 80s, I totally would have joined, as I have great friends in band. Also, I feel like if it's synchronized swimming is an Olympic sport, DCI should be too. I mean, it's pageantry and athleticism. I don't think there is enough of a world component yet for that to work, but it's fine. Jonathan, this was a great question. Jonathan said, can defendant openly discuss the evidence now that it's part of her own public proceeding? No, because it's not part of a public proceeding, because it's an immediate plea deal. So there's not going to be any evidence in a public proceeding. The public proceeding is that information was leaked, that they were a grand juror, and that the information was witnesses' names, but not what witnesses' names, that witnesses testified, but not what they testified to. So none of that's evidence in a public proceeding at this point. It's a good question. It is. So Casey Cat said, Emily, but we don't really know if the feds were really investigating Karen Read or clearing her while investigating law enforcement. The reason I say I don't think the feds were investigating Karen Read individually is because it doesn't make sense to me that federal law enforcement, when there is already a state proceeding going, would look into a single victim homicide, non-first degree DUI. Like, if you're looking at the case, it doesn't make sense that the feds would be investigating Karen Read as a defendant. Like, that doesn't logically track that they would start that investigation. It has to be more than that. It can't just be, oh, this is a second degree homicide. That's not something the feds are going to take up. It's squarely state jurisdiction. Feds can look into state level law enforcement. So law enforcement handling of the case, DA handling of the case, those things make sense. But there's no purpose or jurisdiction for the feds to look into, did Karen Read kill John O'Keefe? Period. Like, that part, there's just no federal jurisdiction there. Nothing in that fact pattern gives jurisdiction. What law enforcement might be up to gives room for federal jurisdiction. So Bruce West had also asked the question that we answered earlier about the phones. 2 question. Will her spot on the grand jury be filled by someone else? I imagine her grand jury service is already done. So will she be able to serve on any jury going forward? This would have to be disclosed going forward. So I imagine that wouldn't go well. Little Mama asked, could this affect her civil cases and could she sue for pain and suffering for wrongful accusation? With regard to Karen Read, the criminal case against a federal grand juror who sat on the Karen Read case, whether or not the leaks were regarded to the Karen Read case, doesn't impact any of the civil cases. And whether or not Karen Read will sue prosecutors for wrongful accusation is separate and apart from this grand juror, because this grand juror, again, doesn't have anything to do with the criminal prosecution of Karen Read in the state court. That's a state level decision. So as it falls with this conversation, no. And if Karen Read chooses to bring a wrongful prosecution claim, that's a much longer and more nuanced conversation. We will see if she chooses to. Froggy Girl asked something similar. Can Karen Read use this info for her civil case? If we are talking about whether Karen Read is going to sue civilly, not really, because this doesn't have anything to do with Karen Read's criminal prosecution. If we're talking about the wrongful death case, also not really, because it doesn't have to do with the Karen Read criminal prosecution. So that. Let's see. Lori Leanne asked, do we know what was leaked? Yes and no. We know that it was witness names, witness testimony, and other evidence. We don't know what witness names, witness testimony, or what other evidence. So yes and no. Kyle said I'd give my eye teeth to read the proffer. Same. All of it. Hannah asked, EDB, do you plan on covering any more cases in Massachusetts? I don't pick cases by jurisdiction. We generally go by interest. There's a couple cases in Mass that I have my eye on, but they are much further away from trial. We have so many things we need to catch up on that are close to trial, things that are further away from trial, newer cases, things that just happened, arrests that just got made, things that just happened are going to go a little bit further down the docket because we have so many things that are moving towards trial. So just because I'm not covering them now doesn't mean I won't. But Lindsay said, I think Dr. B would disapprove of giving your eye teeth for anything. True. We Invisaligned these to exactly where they needed to be. So we don't want to mess it up. Annie from Southie said drum corps, big drum corps nerd, love Crusaders. Who is your favorite? Love Madison and Boston. My son marches Cavaliers. So my son marching Cavaliers is my favorite, but there are things I love from a lot of the corps because I am an enthusiast, but I am also a mom. So the Cavaliers are my favorite. There are shows I love from everyone. I get excited to see drum corps. I'm excited to see people's shows. Truly. So I always look forward to seeing some, I can't even say more contemporary music because now half the music I listen to categorizes as classic rock, which is just rude. But I love seeing shows that are unique. I love seeing good marching. I love hearing good music. I love a drum moment. If you've got a huge like snare snap when everyone catches a rifle, so you get the snare snap plus the like of everyone catching a rifle, I'm going to be geeked. I'm going to be geeked. Geeked. If you weave in a little sassy nod to some more traditional music, I'm going to be geeked. I also understand that paying for the rights to rearrange popular music can be incredibly expensive and difficult. So it's one of those things where I'm like, I would love to see more of this. This year, Spirit of Atlanta has some really fun rearrangements of Rocket Man. And it just makes you smile. Just makes you smile. So yes, I'm an enthusiast. I am to drum corps or I hope I am to drum corps what Snoop Dogg is to like equine events. I am an enthusiast. I understand a bit. Well, I did march band, but I did not march band in this way or in this decade. So I am an enthusiast. Rebecca, Cowboys fan number 1. I watch you all the time. I'm a lawyer, loyal. I had to jump in. Good to see you. And this is wild. Diana said, everything in this case is unbelievable. I have to come up with new words because I keep saying this isn't going to happen. The Karen Read case is so wild that things keep coming up. Yeah, and it's not like there isn't other news going on in Massachusetts. There is so much stuff going on. It's wild. So give us a stay our daily tea. I mean, for real, I hope that when we cover cases and bring up the court documents, that it's easier to parse, like, what do we 100% know? What do we suspect might be true? What questions do we still have? And then what are some of the reasonable, logical conclusions that we can make? Burning Queen said, slap on the wrist for providing info. I mean, 2 years of supervised provision or 2 years of supervised probation is annoying and you have to pay for it. So it's something. But I imagine that all of the information was immediately given up. Like when the feds are filing the information, the charging document, and the plea almost simultaneously, or filing the complaint, information, charging document, and then giving the defense the plea on the same day, they've been working with the feds. That's just what that is. The feds trade in information, 100%. So yes, the feds will know who got the information, what information they got, and probably have all the receipts on that too. Whether they will do anything for that or can do anything with that is really going to depend on who it went to and the other circumstances that we just don't know. Because we just don't know. Let's see. For the kids, what happens to the individuals she spilled the tea to? That's going to really depend on circumstance and who they are. What initiates a grand jury, or they just go to trial? Noni's treasure hats. I'm trying to answer that succinctly. The grand jury process, as we talked about a little bit earlier on stream in more depth, but the grand jury process and the preliminary hearing process are part of probable cause. Can the person that the government thinks did a thing be held over for trial for the thing? Whether that's on bond, on bail, in custody, on own recognizance, whatever it is. Is the person charged with the thing reasonably likely to have done the thing enough that they should go to trial for the thing? Is there enough evidence there to do that? So some jurisdictions do that mostly by preliminary hearings. Some jurisdictions at the state level do that by grand juries. Some it's a mix of both depending on the circumstances. Sometimes it's a grand jury to seal before they go arrest a person. Sometimes it's a state charging a person that's in another state and they need to get the indictment back so they can go get the person in the other state and bring them back, or the other country for that matter. And the feds use almost solely grand juries and work their cases up pre-arrest. Things that just get arrested in the day-to-day life and operation of law enforcement generally don't go to the feds. Pharmacist Kiriopi said, how do they choose who sits on a grand jury? Is it the same as regular jury duty summons? Yes. And I don't know how the different systems like put everybody's name in a lottery and pull them out. I have no idea how that works. I would love to know. I don't know. Eileen said, I marched DCI for years. Amazing. Which corps? Tracy Ann said, EDB, thanks for explaining the grand jury process. I find it fascinating. We don't have grand jurors here in Canada. And again, each jurisdiction is different. Each country is different. Warwicky Becky said, I got an email from Fathom Events. They're showing the DCI finals live in select theaters August 7th, 3:30 p.m. Pacific for like 5.5 hours. I was like, I know what that is. Exactly. I think they are also streaming on Flow Marching, and I am going to have a code for y'all on that. So hang tight. Lori, I know we answered this. Grand jurors get a daily pay, but not like a job pay. Wendy said, so if you can't talk about a grand jury, why are they allowed in a regular trial to ask about what they testified to at grand jury? At that point, their prior testimony has become unsealed through court process because you can't hide from a defendant what a witness said in another proceeding. So by the time it goes to trial, portions of the grand jury are unsealed. And then if a grand juror talks to a friend about, oh my God, did you see that person testify at trial? And they said this and this and that, they can talk about that. I'm like, oh, they said they were at a grand jury. I know, right? You can talk about that. But other parts of the grand jury, witnesses that didn't get called, evidence that didn't get shown, what the attorneys asked them, if that doesn't come up in unsealed, is still sealed. So then it becomes a partial. Some of the stuff's unsealed and some of it's not. And my mom said, we are here for the facts and that's why we love it. Even when we talk about the not facts, we always specify what's not facts. The fuckery just keeps coming. It feels like it because there is so much. There is so much. Casey Cat said, not a paid advertisement, but my new purple Launer tumbler is epic. It was in the 90s at DCI last night. My water stayed ice cold without ice for hours. I love them too. We are working on restocking. We're going to have to restock in a slightly different color. So I'll tell you about that because the globe is apparently out of the purple. Rude. The Lawnards love the things. And then we buy them all. And then people are like, we didn't expect. Irish Rover said, marching band memory, band party one night, had practice in the morning, performance in the afternoon, coming through the tunnel for practice. Everyone was wearing mirrored sunglasses. Looked like a solar farm. People vomit on the side of the field. It was like, no, coach, it's hot. Water break? Band director's like, no fucking water break for you people. There were a time or two in college where the water polo team was a little vomity. And our coach was just like, no. And I'm like, I swear the water's making me motion sick. He's like, the water's making you motion sick, Baker. Well, not Baker at the time. Because you're hungover. I mean, facts. Baker doesn't like being hungover. We don't do that because it does make me motion sick. We even broke purple. For the moment we did. For the moment we did. Brandy B asked question, can we fairly assume that she spilled to someone of authority and that is why she was caught? Who would benefit from this knowledge? Who would benefit from this knowledge is a great question. I think there's probably a lot of people in there. I don't assume that it was spilled to someone in authority because there's always the possibility that you end up in a game of telephone and it's like she spilled to somebody who then went and told somebody and then was like, oh my God, did you hear a grand juror? There's like a lot of ways that can get looped back. But things can be interwoven and we don't know how many devices the feds have grabbed in connection with all the different things going on in Massachusetts because there's a lot of things. Who benefits is a fair question. And I think that question could be answered a lot of different ways. Miranda, this is a really interesting question. I think it raises a lot of ethical obligations about whether an attorney would have to disclose it. And I think there are a lot of circumstances where if the juror told them directly, that is the case. I think it gets really muddy if they're told by somebody who's told by somebody that they heard from somebody, like heard it from a friend who heard it from a friend who heard it from a friend, that grand jurors are saying this. Or if they get a, hey, this person said this over there, it becomes a whole thing. So I need more information. But if a grand juror spoke directly to someone who's obligated to disclose that and they don't, then that can become a problem. Circumstance matters a lot. And aren't lawyers good at arguing nuance? and circumstance. Yes, they are. So we just don't know. Jamie said, always been curious and you explain things in a way I understand. Can you explain the hearing orders after an arrest, like probable cause hearing? I can. Hopefully we did this a little bit earlier, but generally, because there are some variations to this, there's some little asterisks. Arrest, probable cause hearing, which can either be a grand jury or a preliminary hearing. However, if probable cause happens before arrest, then you don't need that step. Like a flow chart. So arrest, well, then arraignment, where you have to be advised of the charges against you, then probable cause hearing. Asterisk, unless the probable cause hearing happened first, then arrest, arraignment. Then your clock starts ticking for trial. And then you have a right to speedy trial and discovery and the rest of it, and then go forward to trial. So let's see. Idritas? I hope I said that right. Iriditas? I'm going to get that wrong. Sorry. Can the judge go with the harshest punishment to try to stop this happening again? If the judge says, fuck that, I'm fining you $250,000, the defendant has the right to withdraw the plea deal. So if the judge says, I'm not adhering to that plea deal, then it's likely, then it's possible that the plea deal will get revoked. If the judge says, I think you should be fined $2,000, and the defense is like, bet that's cheaper than it would be to go to trial, then it might not change the plea deal. But if the judge is not going to adhere to the plea deal, the defense or the prosecution has the right to withdraw the plea deal. So we will see. Let's see. Ooh, Annie from Southie said if you go to the Boston Crusaders website, they have Shipping Up to Boston on it. Amazing. Hold on, let me go look real quick. That's what we're going to roll out with. Hold on. That's 100% what we're rolling out with. The 10 out of 10. We talked about it. It's totally relevant. It's totally relevant to what we're doing now. I swear. Let me see if I can find it quickly. I'm sure I can. That is their show this season for Boom, it's a really fun. Emily, you always say it's a really fun show. It is. It's a fun show. It's a fun show concept. Let me see if I can find Shipping Up to Boston real quick. Emily, how quick can you find it? We'll see. Ali says stream's going to get taken down by the Dropkick Murphys, but it's worth it. I mean, we'll do a little bit. Oh, no, that's the show announcement for White Whale. That's not it. Uh-oh. That means Emily has a meeting. Let's see if I can find it. No. I do not see it on their website. I'm going to have to find it because I do not see it anywhere on their website. I'm sorry, fam. You can probably watch stuff on YouTube. Oh, let me see if they have it on YouTube real quick. Chat, I'm trying. Ooh, we got to go quick. Let's see. Boston. They might have played this arrangement. Oh, did they play this arrangement during White Whale? Oh, the same show. Oh, that's cool. Okay, hold on. If this is up, this is only a few minutes. It means they cleared rights on this because there's a few minutes of it still up through the DCI official website, which means they cleared rights on this. So for all of you educationally who do not know what marching band is, Miguelina's like, girl, you have a meeting in 10 minutes. This clip is less than 3 minutes. This is from one of my favorite DCI shows. I really enjoyed this show. Everyone from Boston Crusaders is just like, you cannot call it the Moby Dick show. It is White Whale. My bad. But for everyone who asks, this is for the educational purposes of explaining something I talk about frequently, Drum Corps International. So for the educational purpose of talking about Drum Corps, we need to look at the clip from the DCI website. And then if we need to give a little bit of commentary, we 100% will, because commentary on band. All right. What do we got? We got the Boston Crusaders, one of 20, I think, world-class drum and bugle corps international groups. You will see the humans with what look like kind of white sticks. Those humans are color guard. Those are the color guard rifles. They are heavy, but because they're heavy, they fly really high. In the front there, you're like, Emily, is that a drum kit? Yeah, it's a fucking drum kit. It's amazing. You can have a drum kit in marching band? I know. Isn't that fucking cool? All right. Let's take a look real quick. I haven't seen this before. Also, you will notice that this is in Indianapolis at Lucas Oil. That's where finals are. The whistle's so good. That was too loud. We need to start over. The whistle was so good. I love this show. I love the kick out. Right? Drop that bass. Let's go. There you go. I really do love this show. It's such a Boston show, isn't it? So for our international crew, there are no woodwinds. There's an asterisk to that. This is brass, drums, guard. Front ensemble, which is also part of percussion. The little spinny white things are sabers. They're not as heavy, but they will bite you. Sabers can be the blade of it is not sharp, but the handhold is sharp. So sabers can be a little fiddly. Yes, we got multiple kinds of drums. You got your snare drums, you got your bass drums, you got your quads. Sometimes they're Keats. They got the little one in the middle. Depends. Love it. Amelia said no wins is a disservice. DCI really is the place where trumpet players get to be their whole selves, and they're not getting yelled at about playing too loud. DCI is really the place for trumpet players who are just like, look, man, I want to be the loudest one on the field. Everyone is that energy. And so they don't get yelled at. However, there is a new rule this year that there can be one featured instrument. That featured instrument can be a woodwind. And we have seen lots of corps take advantage of that. So woodwind players, hear me out. Hear me out. Somebody throwing down a fucking sax solo to Baker Street. There are some other that are escaping my mind right now, incredible sax solos, but I think you could build a show with a really fun saxophone solo to weave it in. But there are now one featured instrument starting this year. So we have seen, I think it's an oboe with Blue Devils in their show doing Uninvited. So DCI has opened up one woodwind. So there's an oboe, but I could see somebody up on top of a prop blasting out a fucking saxophone solo like you've never seen. So, let's see. What? Where is the piano? It's a percussion. There's synth, but there's synthesizers. They're there. So, all right, let's continue. So that was a rule change this year. I had no idea. And then I was like, wait, what the fuck? That's an oboe. And I got confused. There are synthesizers, though. I'm still waiting for shipping up to Boston. Did you see that? Look at that. You didn't see a fucking flinch. Did they just yeet a rifle over the head of the band? Yes. Did anyone flinch? No. Right? Right. Watch that. Over the band. Whoop. Uh-huh. Then the other one went over. Twice. Oh, there we go. Right? Just do you look at how you have never seen a trumpet player as happy as that dude right there. You have never seen a trumpet player that fucking happy. Look at that. Look at that. Look at how fucking happy. Trumpet players who get to just play as loud as they fucking want without getting yelled at by the band director are living their best life. How often does that happen? Not all the time. But that trumpet squeal, that solo right there, look at the joy. Look at the joy. Look at the fucking joy. Oh my God. We're going to back that back up. I love the weaving in of Shipping Up to Boston by the Boston Crusaders in this show. I fucking love it. This is one of my favorite shows. Look at the flag design. Oh my God, it's so good. All of you are like, Emily, you said you could do this in 10 minutes because it's a 3-minute video. Then you proceed to take 15 minutes. Yes. And then we're done. Side quest. We all deserve it. It's been too hard. I'm almost done. Watch the trumpet in the middle. And then the horns blow your face off, right? And you just sit there and go, whoom. This is a 12-minute show. Did you hear that snare snap? The second that rifle hit his shoulder, did you hear that snare snap? Oh, bitch. So, just a little bit. But do you see how fucking fast they're moving on the field we're playing instrument? Damn. Anyway, that was from Finals 2023. Your commentary of DCI is top notch. This needs to be a thing. I am an enthusiast. I am here for color commentary. I am not here for skill. I am an enthusiast. But there are some nods in choreography that are so great. And when you have those like rifle moments at the same time you're getting especially some of those drum snaps, it just feels like the right thing. You get all of it hits at once because when you are in person, you can often hear all of the rifles when they're caught at the same time. You hear them all catch. So you will actually hear all of the rifles also kind of slap. They're just like, so much fun. Okay, so we all had a good stretch. We got to hear some of Wellerman, some of Shipping Up to Boston. We got to talk about Boston and Boston Crusaders. And we got to talk a little bit about DCI. So thank you to DCI International for having the rights to put this up on the internet because I really enjoyed that. And thank you to the Law Nerds for letting me know because that's what it is. Sweet Cat, what does your son play? He throws heavy things. He is in color guard. He loves the spinning and throwing. Synergy, yes. Yes, that is an exact and perfect description. All the time. Oh my God, look at them blow their horns while running. Yeah, me. We will link this down below if you guys want to check it out. it is one of the things. I told you I'm excited. I'm excited about band. I'm excited about it being summer. Trials are heavy. The cases we cover are heavy. Find joy in the hobbies that you love, you guys. It is one of the things. Do not spend too much time in these cases. Unfortunately, for the parties involved in these cases, they do not have that option. They do not have that opportunity. We do. Next year is going to be next week is going to be incredibly difficult. The Kohberger sentencing and everything running up to it is going to be hard. It is going to be emotional. It is going to be sad. Some of the families are going to choose not to show up. We don't know what impact statements will be made or will not be made. There might not be. We don't know. But between the time that the non-dissemination order gets lifted, which is likely going to be Thursday, and the sentencing on Wednesday, there is a book that has just been released. There is a docuseries that has just come out. I think we will see more people speaking to the media than speaking in court. I do not have any kind of emotion about that. If families want to show up and address Bryan Kohberger, they can. If families want to not address Bryan Kohberger and act like he is not going to be spoken to or about, that is completely their right. They do not owe anyone anything. I do not expect that we will hear from Bryan Kohberger at his sentencing hearing. We may. I don't know if we will. I am not anticipating that. If anyone is really hoping that we're going to hear from Bryan Kohberger, I would maybe just reconsider that expectation, because I don't think that expectation is likely to be met. I don't think we will hear from him. I don't know if we will hear from Ann Taylor, because the sentence is predetermined. It is 4 consecutive fixed life sentences plus 10. That part's going to be quick. How much we will hear from those impacted, we will wait and see. But I have heard in the media at least 2 families saying they're not going to show up. So again, if they don't want to be in the room with Kohberger, they owe that to themselves for their healing. If they want to give those statements to media instead, they can. They can do whatever they want. They can release it on their own. I mean, anyone would pick it up. If they just want to put out a statement and put it on the internet, people will grab it. So they don't have to go stand in the same room with Kohberger to be heard. And I think that's actually really a wonderful thing. And it gives families an option to be heard without having to talk to the defendant if they don't want to, or be in the room with the defendant if they don't want to. And the sentencing isn't going to change. Nothing that happens at the sentencing hearing is going to change the sentencing. So it's going to be what it is. He's going to get sentenced to 4 fixed life sentences consecutive, plus 10, with no possibility of parole. That's what he's going to get sentenced to. So anything that happens at sentencing is part of the process, but it's not going to change things. And that's okay. But it's going to be a hard week. So I'm going to spend the weekend going to see my kiddo, sharing some of the behind the scenes with y'all of that trip, and band nerding. I'm going to nerd this weekend and lean into the joy. So if you see me out and about in public, if you are around the events for DCI this weekend, just yell Emily. I will respond. I look forward to seeing you, Law Nerds. Stay in touch in the Law Nerd app. If more shit pops off, I'll let you know there. And we will be back Tuesday. I don't anticipate streaming before then. We've got to record a podcast before then. I'm not sure when or how that's going to be. So members, I will keep you posted. I've got to jump to my meeting. So I will see you soon. I know, Megalina, I know I'm coming right now. I'm a little late. I'm sorry. Streaming is dynamic. Emily side quested. I was on time and then I side quested. I think it was a good side quest. Law Nerds, you're the best. Take care of yourselves. Take care of each other. It's good to see you. And remember, we are here for the facts. we will observe the fuckery and we will be able to distinguish between the two. And I appreciate you. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.